When the opposite party number
No,
two,
you challenge ex parte award annexure 6.
yes, my lords. That is my lord. Starts from page 63, my lords.
But your prayer shows you please to allow same and quash impugned order annexure 1.
That is my lord thereafter, my lord, because I filed application for setting aside of that ex parte award, my lords. That was rejected. That is annexure 1.
That's right. Then you submit something else. While challenging annexure 1, you could have incorporated challenge to annexure 6 even.
That is there, my lords.
So you modify, amend your prayer. If you in fact challenge. But this is not a mistake to take place in your chamber. There appears there is bigger challenge involved. To the extent in challenging annexure 6 also. Prayer doesn't appears to be so. The tripartite learned counsel appearing for the petitioner wants to bring amendment to the prayer. देखिए जदि बॉडी रे भी किसी lapses थिवो करिवे के दिन दरकार
Obliged, my lords.
2 days. Okay.
Yes, my lord.
Let the matter be listed on Thursday. कितने दिन रे?
How much time is required to carry out the amendment? Bring the amendment.
Maximum 1 week, my lords.
1 week.
1 week. All right. List this matter immediately after filing of any such amendment application.
Obliged, my lords.
Item number 2.
May it please your lordship.
Item 2, I have entered appearance through caveat. I pray, my lord, I may be served with a copy before the matter is had.
I'll serve a copy in course of the day, your lord.
What are you challenging?
My lord, I am challenging the order of the electricity ombudsman. My lord, I have a short prayer. The
Mr. Mishra,
Ma'am.
this is a message to bar. You have appeared through caveat means what?
To be had in the
Appear
matter.
through caveat means what? What
be
is
had in the
your
matter.
role and to what extent your assistance will be sought by the High Court?
In case of any interim relief is sought for, my lord, which
Interim. So you should have waited till interim relief. See, I say, I now give some instance of my practice period. Wherever we used to stand saying, sir, I have already appeared for OP and please copy of the brief be extended, the Honorable Court used to admit and grant stay.
Now, only thing is that I thought lest I may be misunderstood.
So therefore,
Pointed out, I
you should have
said.
waited.
As your lordship pleases.
It appears you have more interest in
No, it is
admission.
not a question of interest, my lord. I just
How-
wanted to point out.
What is then?
Your lordship may proceed.
Please, आमे सब हेलेनी बाहर रे आमे इतने experience पर आमे जदी ये जिनिस को continue करिवा कोन हबो?
As your lordship
my lord,
pleases.
I'm only praying that your lordship may take this matter up 2 weeks after. The OERC took up the matter on 22nd of August and they indicated.
OERC simultaneous proceeding before
My lord,
OERC.
there was a proceeding under section 142 of the Electricity Act for execution. But OERC has suo moto indicated that the impugned order is wrong and they have indicated that they will remand them.
Press, you take liberty. If it goes against you, you may come again.
My lord, that order has not been passed by OERC.
Cannot be, but you can't proceed simultaneously.
My lord, that petition is not our.
Considering there is some interest shown by the OERC also on the impugned order aspect. Learned counsel for the petitioner seeks at least 2 weeks adjournment of the matter.
And as my lord has been telling, you just go through the 7 judgments this bench has delivered.
regarding judicial review of
It's already
these
covered.
matters.
Your Lordship, please.
These
So
people.
kindly
they
look
don't
into
have-
that.
Grateful.
Blue Lily Beach Resort and some other, both ways. Blue
Your
Lily was filed by a consumer. Similarly,
Yes.
in fact, after delivery of those judgments, I don't know whether they are not listing the matters.
And there is change
Since
of
my lord
counsels.
started asking,
There is change of counsels. And then again, there is restarting of challenging these orders. Mr. Mishra must not have also gone through that judgment. We have already covered all these issues.
Your Lordship.
relying on the decisions of the Honorable Supreme Court.
A great endeavor by my learned brother,
No big.
and we have
I
put
mean, the
it,
senior most,
put it-
as far as age is concerned.
put it.
So he asked me that, have you gone through this decision? So my point is, Mr. Behra, that I am also learning and reading.
Very, very
Lordship,
recently,
please.
prior to that, there was a Supreme Court judgment taking care of all these issues.
Whether, what is the scope of? I mean, you have been dealing with these matters, not that, I mean, Mr. Mishra is also there, he has been dealing with so many matters.
Go through our judgment also. Next time you may be placing through that.
Your Lordship, please.
Even, even escaping of bench, maybe we don't know what will be the bench then. But judgment will be there. So
My lord,
it will be shown by either side.
that will be staring.
So therefore, please go through the judgment.
Mr. Mishra, if you're, I mean, appearing in execution, you also take care of that. Because the consumer is not benefiting. But prolongation of these things also, that we have also observed in one decision.
It is not, it is to none's benefit.
Only delay part, I mean, today he will pay, tomorrow or after 5 years he is paying, if he is losing it.
Yeah, like there is already appearance on behalf of the opposite party. Contesting opposite party through Sri S.K. Mishra, Senior Counsel and his associates. Copy of the brief may be sought in the meantime on such counsels.
Grateful.
Yes, next.
Obliged.
As it appears. Yes, item 3.
For orders,
My lord,
item
may I
3.
please, your lordship, my lord, I am for the appellant. And there has been 1 year, 2 month, 26 day for filing the appeal in the
Appellant is wife.
wife, my lord. Only I am challenging the part of the impugned order so far quantum of the permanent element
That's
is
right,
concerned.
provided the delay is condoned. What happened to notice?
Because he has already received the notice and already appeared and also filed one counter affidavit.
Yes, where is Mr. Bibhu Prasad Mahanti?
My lord, I'm in the VC, my lord, due to
Hmm.
health issues, my lord, I could not appear.
Okay, this is at the instance of wife and the appeal is confined to the limited extent. So let us condone the delay.
My lord, two issues only I want to bring to your lordship attentions.
Merit
Merit will come. Let us pass.
fast step. If
O-
you are
only-
agreeing to take the fast step, then we will.
No, your lordship, it is,
At
I
the
leave it to your
submission
lordship.
of respective councils. Undisputedly, there is delay in filing the appeal with 395 days. Considering the submissions made herein by respective councils and after going through the grounds in the IA filed for the purpose, further considering that the appeal is at the instance of the wife at the suffering end, this court is inclined to condone the delay, to make the appeal had on merit. Well, it is accordingly, this court allows the IA condone the delay. The IA stand is post accordingly. Yes, appeal you confine to the.
Only so far
only
the
to
quantum. the
Let us
quantum
come,
of
what
the
is the
interview.
quantum? 2 lakhs.
2 lakhs only, my lord.
What is the husband status?
Because the husband is working in the IT sector as a software engineer.
Okay. Your position,
I have no work, nothing, my lords.
you are educated enough,
Educated, my lords, but sitting idle, my lord.
sitting idle, earlier was in employment.
Because that is not within my knowledge.
Okay,
my
all
lords.
right, all right. had main case, right? Matter had on the admission aspect, had the counsel for appellant on the admission aspect in the course of, even though the appeal involved a challenge to the judgment of the family court cutter in civil proceeding 460 of 2018, a proceeding invoked under section 13(1) bracket Roman small 1 dash a cap small a of Hindu Marriage Act 1955, and there is yes, if you agree, both the counsels, just see the judgment. This judgment is expert.
That is the.
So you are now confining only to the quantum aspect.
My lords. But my lord,
And in absence of the wife,
in absence of the wife, my
Wife.
lord, the fact,
so therefore we propose, what we propose,
my lord.
we'll record the submission of the counsel for the wife that she's no more interested for the. So divorce aspect is confirmed. Matter will be remitted only to the extent
My lords,
assessment, reassessment on permanent alimony.
my lord,
But however, since there is already an assessment by the family court,
my lord.
you will deposit this 2 lakh and she will without prejudice.
My lord,
No, my lord, I have
if your
already,
lordship will
I have,
permit- If your lordship will
He will
permit me, I'll
deposit-
clarify.
I have already received
I'll
my lord.
clarify only two things.
Or deposit is a negality.
Already deposited,
Alright,
not at all an
if he has
ex parte order, my
received,
lord.
if he has received, then that will be without prejudice.
My lord, wife is working.
So she will bring a application on 25
Yes.
2 of the HM Act.
Yes, yes. My lord, two things I want to clarify only before your lordship will pass.
କୁହନ୍ତୁ କଣ କହୁଛନ୍ତି?
My lord, the subject to correction of my learned senior, my senior, my lord, the wife is working, my lord.
Oh, we are, Mr. ଆପଣ favor ରେ କହିସାରିଲୁଣି. All these things will be thrashed out.
Entertain.
No,
Then
no.
you have thought that no, let us.
No
since it is ex
purpose.
parte, no purpose, you get an opportunity. You
Only
must-
I want to drop.
ସବୁ ପାଇବେ. ଶୁଣନ୍ତୁ, she will bring.
ତାକୁ claim କରୁନାହାନ୍ତି, 25 କରନ୍ତୁ. Husband to file, he is entered, ଆପଣ 25 file କରୁନାହାନ୍ତି.
Already 3,500 ଟଙ୍କା ଗୋଟେ CMC ରେ
ଏଇ ତ ସବୁ husband proper ଆଉ।
ହେଲା,
ତ 25 file କରିବେ।
both party will not be prejudiced.
Yes,
Okay,
yes.
just listen our order.
Yes,
Just listen.
yes, ma'am.
Had the okay, even though the CP proceeding so and so it is brought invoking the provision under section 13(1) so and so of the Act, and there has been grant of divorce further with grant of permanent alimony to a sum of rupees 2 lakhs in favor of the wife respondent. However, in the course of submission, learned counsel for the wife has taking this court to the appearances through the impugned order itself and the ground in the matrimonial appeal contended. There has been, even though the wife is not interested in reunion between the parties, but looking to the quantum aspect is concerned, there has been permanent alimony granted in a gross lower side. For the submission of the learned counsel for the appellant, the wife intends to confine the challenge in the proceeding only on the aspect of the permanent alimony. Okay, this court also involved, in the course of submission, it has also been brought to the notice of the court by both the counsels that following the judgment to the imputed judgment in the civil proceeding 460 of 2018, there has been already deposit of the sum of rupees 2 lakhs by the husband. Deposit करछन ना RTGS रे पठेई देले.
नहीं आमे क्या पठेइतलु ड्राफ्ट से रिसीव
Okay,
कर
all right. Deposit by way of bank, and the wife is already in use of the said amount.
इन कैश
Okay, considering this would also involve submission of learned counsel for the husband appearing here as respondent by way of notice in the limitation matter. There is no dispute by the counsel for the husband that the wife appellant is already in receipt of the permanent alimony to the tune of rupees 2 lakhs being sent by the husband by way of bank draft. Counsel for the husband also brings to the notice that once the wife has already accepted permanent alimony, there is no availability of the scope on the part of the wife in assailing the order so far it relates to divorce is concerned. This court, on the consideration of rival contentions of the parties, find the CP 460 of 2018 has been decided ex parte in non-cooperation of the wife. This court herein above already recorded the stand of the wife through her counsel that she is no more interested for reunion. And for the submission of the learned counsel through the petition, it appears wife is interested in the appropriate grant of permanent alimony. This court, in the process of consideration, find the permanent alimony and maintenance aspect comes through the provision section 25 bracket 1. The provision reveals as follows. In a 25 1, 2, 3 or Sabudaba. Reading the aforesaid, this could find And looking to the limited extent of challenge by the wife here in this court find any court exercising jurisdiction under the HM Act at the time of passing any decree or at any time subsequent thereto on application made to it for the purpose by either wife or husband order the husband shall pay the party responsible shall pay for her or his maintenance and support such gross sum or such monthly or periodical sum for a term not exceeding the life of the applicant as having regard to the respondent's own income and other property, if any, comma, the income and other property of the applicant. Apart from the above legal provision, this court has also come through a decision of the recent decision of the Honorable Apex Court through Rajnish versus Neha 2021 bracket 1 volume the case. Supreme Court SCC case. The Honorable Supreme Court has also come to lay down the areas of concern in undertaking permanent alimony and maintenance exercise. It is keeping in view the decision has involved herein has been taken expertly and further also keeping in mind the interest of the wife presently involving such dispute, the proceeding, the impugned order is interfered in part while confirming the judgment of the family court so far it relates to divorce is only remitted to the family court cutter for limited purpose of considering on the proper permanent alimony. For there is already joint submission of the councils that the wife is already in receipt of the sum of rupees 2 lakhs. This court observes the receipt of the wife already in receipt of 2 lakhs be treated as permanent, a part of permanent alimony and without prejudice to her rights and contentions to be adjudicated in the remand CP proceeding, civil proceeding 460 of 2018. This court, while remanding the proceeding to the limited extent indicated herein above, direct both parties to appear before the family judge family court cutter on 1st of August, for there is attachment, for there is requirement of consideration of the case, keeping in view the provision at section 25 of the Hindu Marriage Act 1955, the wife respondent therein is permitted to bring appropriate application at least within 10 days of appearance on service of such copy on the husband, the petitioner therein it shall also be open to the husband to bring objection, if any, for consideration of the court also within a further period of 7 days of service of such copy. Further, for there is relevance through the judgment in Rajnish versus Neha 2021 to SCC 324 hyphen Koto AR 2021 SC 569. Further also, the judgment of this court, এটা ये କରିଛ ସେ ଯୋଉ wife ପାଇଁ ଭୁବନେଶ୍ୱର 33 proceeding 33 ମାଟା 33 ରେ ହେଲା ହେଲା also there is relevancy of a judgment, recent judgment of this court, also taking into help of the judgment of the Supreme Court in Rajnish versus Neha. The husband petitioner, while directed to bring an affidavit strictly in terms of Rajnish versus Neha, also within 2 weeks of the appearance, with opportunity to the wife respondent therein to bring her objection within 7 days further, and the trial court, the judge family court directed to take a decision on appropriate grant of permanent alimony, taking into consideration the decision through Rajnish versus Neha of the Honorable Appeals Court, Supra Kartya, and decision Amuka versus Amuka 33, again Supra. The further proceeding in the CP 460 of 18 shall also be concluded with at least within a period of 4 months from the date of appearance of the parties. Appeal succeeds, but in part, no order as to cost.
Only one prayer that both the parties shall file their assets liability affidavit as per Rajnish versus.
Sorry, you have not gone through that judgment probably. Judgment Supreme Court Rajnish Neha has categorically said property, if any, of the wife or father or mother or grandparents shall not form part of the assessment of the permanent alimony. Please, bar, let the bar go through such judgments. The judgment is giving a completely clear dimension. And our judgment, we have already dealt with that and keeping in view all the aspects.
Filing assets and liabilities mandate one. Without filing,
Filing no.
Highlighting that only that you make your submission in one sentence.
my lords,
That should have been your opening sentence.
my
That is not in terms of Rajnish versus Neha.
Nobody is reading those judgments. What happened to bar, I don't know. Our days we say any judgment comes, maybe all judgments were not available then. It's only through reportings. Any judgment reported, we used to go through those judgments. Now every judgment is on board. Within 2 days, 3 days, we offload this. So please, bar, I request the bar, please spend at least half an hour time in a week to go through what are the judgment passed by the High Court. Just have a glance. Just have a glance. Weekly ketera judgment High Court receiving. Sir, yes, it is not in terms of Rajnish Neha and our High Court judgment. Go through. We have given, even today we are signing. We have already dictated that judgment on Friday. We have taken how the care should be taken in respect of a divorced wife and the small child, if any. 33 we decided in case of a female child, and the case we will be signing today, we have decided in case of a male child, vis-a-vis the divorced wife. Complete shaping the mind of the councils. Please go through these judgments.
Urgent certified.
ବଡି କେତେ ଥାର୍ଟି ନା ଆସିବ ଇଏ
My lord,
Item 4,
Urgent certified.
May I please, your lordship? The expert judgment, the wife appellant is challenged the expert
why are
judgment.
you not removing the defect number 9?
The minor defect, my lord, your lordship kindly.
Minor defect.
So, age, regarding age of the
Age of the appellant and respondent are
same, but it is not same.
liberty ନେଇ court ରେ ଲେଖିଲେ ଲେଖନ୍ତୁ minor
କରିଦିଅନ୍ତୁ।
ଜାଗାରେ କଣ ଅଛି? It's the condemnable ନୁହଁ।
Lordship,
Can we entertain that without
ଇଏ
mentioning?
fine,
Permission ନିଅନ୍ତୁ।
permitted,
on
permitted.
oral request of the counsel for
My
appellant.
lord.
This court permit ଆପଣ ଏଠି ତ ଲେଖିଛନ୍ତି ବୟସ
Not same, my lord.
Certified copy ଗୁଡା ଦେଲେ ଏଟାକୁ
Thirty.
ସେଥିରେ ଲେଖିନାହାନ୍ତି। ଆପଣ ମ୍ୟାଚ୍ ହଉନି କି? ଭ୍ୟାରିଆନ୍ସ ହେଇଯାଇଥିବ।
ଆପଣ ବଢିଆ କାମ କରୁଛନ୍ତି
30,
ଏଇଆ ଶିଖିଛନ୍ତି ଆପଣ 35 ଲେଖା ହେଇଛି 21 ରେ କେସ୍ ଫାଇଲ ହେଇଛି ଆକର୍ଡିଂଲି 35 ଲେଖା ହେଇଛି 21 ରେ କେସ୍ ଫାଇଲ ହେଇଛି ଆକର୍ଡିଂଲି 2 years add ହେଇଯିବ 3 years add ହେଇଯିବ that's all
finally be permitted, my lord.
ଏଇଟା ବି ହଉନି ଆପଣ ଅଲରାଉଣ୍ଡର ବୋଧେ ନିଜେ ଲେଖୁଛନ୍ତି ନିଜେ କରୁଛନ୍ତି ଆପଣ ଅଲରାଉଣ୍ଡର ବୋଧେ ନିଜେ ଲେଖୁଛନ୍ତି ନିଜେ କରୁଛନ୍ତି ଟାଇପ I feel ashamed.
My lord, I finally accept. My lord.
Yes, on oral submission of the learned counsel for the petitioner, appellant he is permitted to make necessary corrections in the first item, strictly in the age aspect, bringing it strictly in terms of the disclosures to the impugned judgment CP 51 of 21. Hello. Yes, court re karibe.
My lord.
Now, the
Expert
defect
judgment.
removed. You have a limitation, Pitsa.
My lord.
This is an application by wife.
My lord. The
who
wife
is-
appellant is the said expert, but the fact remains it was
No,
not,
that's right, that's
notice
right.
was not
but,
sought.
Unless a delay is condoned, can
My lord.
we
My lord.
enter into merit of the case? So take notice in
Limitation,
limitation.
notice, my lord. My lord.
Yes, undisputedly, only 414 days delay.
My lord, when I have filed a restitution of conjugal rights petition at Kendrapada in my residence,
Why you wait for that?
I don't know, my lord. It was said
It's
behind my
expertise.
back, my lord. The
Expert.
notice has not
What
sought,
is expertise?
my lord. Expert judgment, my
Okay, all right, all right. Issue notice in the question of admission in the limitation, okay? Let requisites be filed as undertaken by day after tomorrow, but along with both sides xerox copy of the memorandum of appeal and the impugned judgment herein. And a limitation aspect will be listed immediately after appearance of the husband here, respondent herein. The opposite party here, husband opposite party herein. Hello.
Speed post.
It second order ta hala miss case re. First order ta hala MA re.
My lord, through speed post. Through speed post, my lord.
By your speed post, all right.
Oblige, my lord.
item 5,
Despite notice by paper publication, no one has appeared till date.
Any subsequent any notice?
My lords? No,
Notice?
after that, your lordships directed for paper publication. We
yeah.
have taken out that. But still nobody has
Okay,
appeared.
paper publication there, then what was the date of appearance? 12/7. That also expired.
That also expired.
You have taken out notice in several papers.
In 2 newspapers. One Kendrapada edition and one in Rourkela edition.
You are an establishment. Did you send in their address?
Yes, my
everybody?
lord.
What is the information?
Earlier, the change was that Kendrapada and Cuttack, if your lordships remembers, that address was mistaken. So we took out the paper publication both at Kendrapada as well as at
No,
Rourkela.
you have also taken out notice in Rourkela address?
That has also returned.
That
Answered
is
that
returned,
earlier.
no doubt, but you are an establishment. Should you not send somebody to that address at least to find is there or not?
Because he also was
But
expert in the
see,
tribunal where
ultimately-
also the paper.
Ultimately, holding somebody expert is a very small affair.
Yes, ma'am.
It's not that serious. After so much endeavor, we can make somebody, and he's a workman.
That is why, my lord, I'm not pressing for it. So we'll find out, my lord, as a last chance. Your
Okay,
lordship
let
may
us
say
then
we'll
make
find
in
out
view
if.
of the endeavor, let us make the service aspect complete. And
Because
release
earlier
the
also in Rourkela also he didn't appear and was set ex parte, and the paper publication was also
is
taken in
notice
Rourkela
issued in
in
this
ID
matter?
case.
Notice is already issued.
Notice is issued.
Okay, what was the small issue involved here?
What issue is in 33 2B, while deciding the 33 2B application, when the court itself holds, or the tribunal itself holds, that it was an ex parte proceeding where the opportunity was not given to the workman, not ex parte. In fact, it was against the principle of natural justice because he was not given the opportunity to adduce other evidence apart from him, the other witnesses. So can he reopen the issue in the 33 2B application regarding the sufficiency of evidence?
Sufficiency of,
Evidence in that, in
but
the.
that is provided. 33 also includes
No,
dispute.
only prima facie case. Only prima facie case has to be seen in 33
Yes.
2B application. And the notice to be seen if notice has been issued 1 month notice, and
Okay,
the
let us-
payment.
He has no section 29 application pending,
No, nothing.
nor execution any. Then where has he gone? Is he dead?
Lord,
And the 33 C2 is also expired.
33 2B
Sorry, 2B is also expired.
also expired. He didn't contest it also from the very beginning itself.
Yes, we are remanding the matter, and utmost care should be taken on the service of the
Notice
from
of-
the party. Maybe
That
if
also-
necessary, special messenger notice will be sent in all addresses.
All address,
At the
all
cost of
available.
at the cost of the management.
Yes, my lord. That absolutely we know.
Right, at the submission of Sri Nanda, learned senior counsel, along with Sri BP Panda. Considering expert in nature of impugned judgment involved herein, in a 33 2B
2B
proceeding, 2B of Industrial Dispute Act proceeding, this bench was inclined to issue notice on admission to find the determination of the dispute at the earliest by its order dated 21/6/23. Notice being issued pursuant to above direction, notice came returned unserved on the workman. Finding workmen need to be heard in such matters, as ultimately, in the event of interference in the order, the workman was to suffer. This court again by order dated which order directed for paper publication? Yes. In the order dated 21/6/23, sorry,
2023.
the proportion, okay, for the finding, early disposal of the matter, while directing issuing notice, this court, while permitting the management herein to issue notice on OP number 2 by your speed post registered post with AD, fixing short returnable date, finding a long-run battle between the parties. This court also permitted the management to take out notice on opposite party number 2 by way of paper publication in a local daily on the opposite party number 2, both in the publication at his permanent address as well as his place of service. Consequent upon above direction, it appears there has been paper publications in both the permanent address of the workman OP number 2 as well as service place of the workman opposite party number 2 herein in several publications, in multiple publications. All such publications, okay, getting into the advertisement made for the purpose, this court find all such publications had a clear indication for appearance of opposite party number 2 in this court on 12/7/2023. 1.5 months, nearly 1.5 months have passed in the meantime. Unfortunately, there is no appearance on behalf of OP number 2 as on date. Finding there is service of notice sufficient on the workman of OP number 2, this court proceeds and keeping in view the nature of dispute involved herein, particularly an ex parte impugned order passed by competent authority, this court feels it up to avoid any further wastage of time, felt it appropriate to proceed in the final outcome of the matter. For non-cooperation of the opposite party number 2, the matter is taken up for final hearing only in the involvement of the submission of counsel for management, besides also taking into account the plea of the parties in the authority below, as well as the observation and findings of the authority below involving the impugned order. In course of submission, Sri Nanda Learned Senior Counsel brings to the taking this court to the impugned orders while raising serious question on the exercise aspect with the industrial adjudicator, the presiding officer, Industrial Tribunal Raulkela, particularly keeping in view a proceeding under Section 33(2)(b) of the Industrial Dispute Act 1946. Also brings to the notice of the court the nature of disposal of the proceeding being ex parte, particularly that proceeding was brought by you.
Yes.
Particularly the workmen also remaining ex parte in the proceeding ID Miss Case 46 of 2000. For a serious for this court find undisputedly the proceeding was decided though against management, but however in non-cooperation of the workmen. This court find there is raising of a serious question required to be adjudicated. Perusal of the impugned order, this court find. Where is your written? Where is your petition under 33(2)(b)?
That is annexure 1 from page 18.
Please take us to that ground. Okay, that ground could not have been
It could
there.
not
because
have been
It is
because-
all taking place in the course of hearing.
Yes.
This court here on this court going through the impugned order fine. Even though there is no framing of such ground, there may not be finding any surprise with the management raking such ground in the read court even. This court finds the question raised herein as to looking to the limited nature of proceeding involving section 33(2)(b) of the Industrial Dispute Act 1947, whether the industrial adjudicator competent enough to go into the appropriateness in the inquiry.
Appropriateness in the inquiry and merit of the issue. And the
My-
merit of the issue, my lords.
Merit in the
In the departmental proceeding. That is
Appropriateness.
reappreciation of evidence.
Has the competency to find out appropriateness in the appropriate or inappropriateness in the disciplinary proceeding involved therein. Hala. For there is expected disposal and there is no adjudication on this aspect. This court feels it appropriate and the question since a serious one. 10(2) there is no issue.
There is absolutely.
Then 2A there is also no
No
issue.
issue.
But 32
33(2)(b) is very limited extent
limited.
because it
Right.
can again be
Without expressing any opinion on the question raised herein. This court interfering in the impugned order at this stage, simply remand the matter back to the industrial adjudicator to involve it in re-adjudication of the proceeding, while also giving answer on the question framed herein above, but in the involvement of the management as well as also the workman. In remitting the matter for the observations next para, for the observations made herein above, this court find difficulty in bringing the workmen to the contest fora. From the impugned order, it also appears the workman was not appearing. It is unable to be, the position of the workman unable to be assessed at this stage. Keeping this in view, this court, while remitting the matter and directing the in the reopening of ID key, Miss Case number 46 of 2000, this court direct the management petitioner here to appear before the industrial adjudicator, the presiding officer Raulkala, on 1st of or ta paro week kariba
any subject to your lordships.
On 11th of
11th.
September on production of copy of judgment of this court. The tribunal shall do well in directing the management to take out notice by special messenger at the cost of the management in both the address of the appellant.
In all the available addresses, your
In all
lordships.
the
may send.
available
Just 3 addresses
of the
were there.
workman. Right. To ensure there is sufficiency in notice on the workmen involved herein. Before parting with the case, this court observed observations, if any, made herein shall be for the purpose of adjudication of the case at hand, and there shall be no waiving of such observations in the fresh adjudication of the ID Miss Case 46 of 2000. The petition succeed to the above extent, no cause.
Obliged.
personal appearance direct ଅଛି।
Personal appearance ଅଛି।
10-11 ଗୋଟେ joint
No,
affidavit
ଟିକେ
ଯାଇକି
ଗୋଟେ 10-11
13ଟା joint affidavit
10-11 13ଟା ଆଗ ଡାକ joint application ଅଛି।
item 13
13 file ଟା ଏଠି ଦେଖ
13
153
ସାହିତ୍ୟ କଣ ଭାଇ
153 by
Met
Yes, there is joint application of settlement
my lord.
in the reunion or in the permanent
No,
alimony.
living separately, a permanent alimony of 7 lakhs that has been paid.
So you are satisfied,
I am the wife, my lord.
or you are the wife, you are satisfied with
My
that.
lord.
Along with the fossil watch, my lord. There is a fossil watch.
Pardon?
7 lakhs along with a fossil watch that was given during the marriage. They have written that fossil watch and 7
That
lakhs.
also they have taken back.
My lord.
Where is the affidavit? Joint affidavit, yes, it is here.
Last order, your lordship had mentioned this.
Okay. The appeal involve a challenge to the final judgment and order in CP 127 of 20. In the appeal at the instance of the wife, there has been joint endeavor to arrive at settlement between the parties in the better interest of both parties. In the process, both the parties your case was 13-1, na? 12A and 13-1.
My lord.
Okay. So you abandon the proceeding and settle the matter.
My lord.
There has been filing of joint affidavit in the abandonment of the proceeding between them. But however, keeping in view the future interest of the parties, both parties have come to resolve their dispute as follows. Para 2 7% to 2 to 7 4%. Okay. In the personal appearance of the counsels, physical appearance, both counsels jointly submit that there is in fact agreement between the parties in terms of the affidavit dated 7/8/23. In the meantime, there has been also payment of the sum of rupees 7 lakhs as agreed between the parties in para 4 therein. First installment of rupees 3,50,000 being paid on 7/8/23, and in the meantime the balance sum of rupees 3,50,000 along with fossil watch given at the time of marriage has also been handed over in favor of the wife. Keeping in view the above development, this court finds there is no further dispute surviving between the parties. The matrimonial appeal stand disposed, but in the joint interest and in the terms and conditions recorded herein above.
Obliged.
Personal appearance कौन अच्छी दीटा का?
item 10 Item 10,
Item 10, party personal appearance আসছেন আଜି?
No, my lord, they have shown them on behalf of Devashish Tripathi or for respondent.
On behalf of,
Devashish Tripathi.
you are for Devashish Tripathi.
Yes, on behalf of Ratnabala Pradhan, on behalf of Devashish Tripathi, I am.
ଆସିନାହାନ୍ତି।
No,
ଇଏ ଦିଲ୍ଲୀପ ପ୍ରଧାନଙ୍କର
ସେ ଆସିନାହାନ୍ତି।
ସେ ଆସିଛନ୍ତି କି?
ଆସିନାହାନ୍ତି।
କଣ କରିବା ତାହେଲେ? ଖାଲି ଦିଲ୍ଲୀ ଯିବ ତ। ସିଏ dismiss କରିଦବା appeal non cooperation। This matter is on board on several dates. As a matter of first attempt, considering the daughter of the party was prosecuting nursing course in an institution at Bhubaneswar. This court directed the father for providing at least a sum of ₹2 lakhs. Which came to be deposited in this court by way of draft bearing 251106 dated ये दिलीप there was the this matter is on board on several dates. Benefit of the daughter. कौन था ना प्रिया?
सेलिना प्रियदर्शनी महातो।
देखियो previous order रे अच्छी से नाटा is directed to the handed over to the counsel for the wife involved hearing, like keeping proper endorsement. The counsel for the wife also is directed to furnish a receipt of the party involved. And in the benefit of such, সেটা ঝিওটা কোন minor ঝিও কি?
Minor.
ও তাহলে the mother of the minor daughter involved herein. Within at least within 7 days. matter be listed 3 weeks after करबे आउ ହେଲା ଏଟା ତାଙ୍କୁ ସେ କେସ୍ ରେ ଏଟା 113 ରେ ଅଛି
Your Lordship, can I pray one thing, Your Lordship?
113
Duty করে আছে তা কইলে
ଦେଖ 113 ଫାଇଲ କି ନେଇ ଗଲା କଣ
Okay.
ଉଠି ଯିବା 12:30 35 ରେ ବସିବୁ
Can Your Lordship, it is next week, Your Lordship. Next week, as
Please,
In the first case, my lord,
please be on mic.
my lord. Item one, first item, my lord. I had the consultation operation is going on in my locality. I had applied for to participate in this time, but I have been denied. My representation is still pending before.
What is that application?
At page 26.
What is that application? What do you want in that application?
I want that I should participate in the consolidation operation. In the consolidation operation, I should operate.
Then how?
Because I am the
how a representation was? Any consolidation proceeding pending?
my lord. Section 11 is now functioning.
What is your interest in such property?
I am the owner of the land. Since Britishhood, I am the Khewardar.
Come to any of the representations submitted by you. Come to any of the representations submitted by you. Has the disclosure of property? Dekhele.
No, I am not mentioned the disclosure.
Then how such representation will be taken into account? There is no head and tail. So I submit if section 11 proceeding going on,
my lord.
If you bring any application for your participation, giving details of property,
My lord.
you will be allowed to participate. That's all.
Yes.
Had the submission of plan.
Section 9 pits down. Section 9.
Section 9. Okay. Counsel for the petitioner bringing to the notice of the court that there is undertaking of section 9 of OCH and PFL.
Yes.
OCH and PFL Act proceeding by the Assistant Consultation Officer Nimapada. It is alleged the request for participation of the petitioner is illegally involving some property is illegally torn down by the Assistant Consultation Officer Nimapada. Through representation answer 3 series, it has been brought to the notice of the court that petitioner's written request is also not accepted. State Council, however, objects acceptance of such representation for having no head and tail on the properties involved. This court finds strength in the submission of State Council and observes there is no possibility of giving any direction on the representations at Annexure 3 series. The representations thus stand disposed, however, observing in the event petitioner brings appropriate application, giving details of the properties required, he is interested for participating in the section 9 proceeding, at least within 7 days hence, and section 9 proceeding is still pending. The Assistant Consultation Officer Nimapada shall do well in providing opportunity of contest to the petitioner involving such particular property. With this observation, the requisition stand disposed. ये सबुड़ाक सही case?
No, no, no. Second time, my lord, mutation case.
Huh?
My father had filed the mutation case.
Oh, you would have been telling the second matter is something different. You would have telling serial number to aloga. Gote memory de do chundi bote apan.
Nothing the
Tinta memo ekati kon kemti kardale sitaku. It's not a batch case.
The mutation case was filed by my father in the year 2006.
Second case re?
Second case, my lord.
Copy application has not been accepted.
Yes. The order has not yet been complied.
Huh?
Though it has been directed to record the land in my name.
Second case ta apna dharchandi brief 23440.
My lord.
Okay, it a third case.
23439.
Sorry. Third case lekha copy application pending by annexure 2 be given lawful disposal by completing work required therein, exercise required therein, at least within a period of 7 days of receipt of copy. Third case.
Third case.
Copy application annexure 2 pending.
Pending both.
Now second case.
Second.
ଦେଖନ୍ତୁ annexure 2 ରେ copy application ଟା pending ଅଛି.
Copy application ରେ discrepancy ରହୁଛି annexure 1 and annexure 2.
ନେ ମୋ ପାଖରେ annexure 2 ଦେଖା ହଉଛି ଏଥିରେ.
Annexure 2 ମାନେ. Annexure 2.
ये तो हुए batch case सब file कले माने check करते annexure 2 page 14.
Yes.
मुंडा.
Miss case number 1 of 2014.
ଶୁଣନ୍ତୁ ମୁଁ କହିଲି ଆପଣ lawful disposal ଆପଣ ମତେ କାଇଁ ପାଠ ପଢଉଛନ୍ତି ଏଠି ଆପଣ ତହସିଲଦାର କୁ ପାଠ ପଢେଇବେ ସେଇଟାରେ ଯଦି ମିଳିବାର ଅଛି ମିଳିବ ନ ମିଳିବାର ନାହିଁ ହଁ yes next yes second case ଟା କଣ କହୁଛନ୍ତି ଆପଣ
My father has filed the mutation case in the year 2006. Order it was directed to record his name, record the land in my name.
Taking this court to the order dated 8/2/2018 in the disposal of the mutation proceeding involved therein. A claim is made for bringing out the appropriate record of right. This court finding innocuous request involved wherein observe in the event the order dated 8/2/2008 in mutation case 2812 of 2006 is still in operation. There may not be any difficulty in bringing out appropriate record of right by completing entire exercise at least within a period 1.5 months from the date of communication of order. Tinta kare free copy de diyo na.
Okay.
Item 2.
Please, your lordships. In the given case, my lord, the grievance of the petitioner is required to be considered by the collector, as because on the graveyard the project is going to be constructed by the government authorities, which is not permissible in the eye of law, your lordship.
Pardon? What is your prayer?
Prayer is with regard to objection of the village people, my lord, with regard to construction of a health, a daycare sub-center.
What is the position of the construction? What is the position of the construction? Why have you made such? Where have you made such declaration?
Lord, by the annexure, my lord, 6, my lord, in the month of on 25/5/23.
No, that's right. You have given a complaint there that is pending. Everything is there. But question is, this was a work order on 28/3.
Let them take a decision, my lord, because
आपंकर objection किछि अछि?
My lord, it is a graveyard, my lord. The village people.
Annexure 2.
My lord, annexure 2 is required to be disposed of. My lord.
All right. Considering prayer court, considering innocuous prayer involved in this court, even though is not inclined to interfere in the work order annexure 5 at this stage, however, finding petitioners have already a request by way of objection on the site selection involved in annexure 5 submitted on 12/4/23 appearing at annexure 2. This court observed. Let the collector district magistrate Ganjam take a lawful decision on the objection at annexure 2 pending therein, at least within a period of 15 days. Right. Of the date of submission of copy, free copy de diya.
Item 3,
କଣ ହେଲା ସେ ଆଉ କୋର୍ଟକୁ ପଳେଇଲେ ନା ମୋ କୋର୍ଟରେ ଅଛନ୍ତି ସିଧା ବନ୍ଦ କାହିଁ କରିଦେଲେ ଅନମ୍ୟୁଟ କରିଦେଲେ
It auto,
yes you want early disposal of the election dispute
my lord.
but dispute is hardly 1 of 23 କେତେ ତାରିଖ ଫାଇଲ ହେଇଥିଲା
It is received on 17 February 23, your lordship.
ହେଲା ଆଉ ୟାକୁ ଆଉ ଟାର୍ଗେଟ ଏତେ ଶୀଘ୍ର କଣ ହବ ଏଗୁଡାକ
Disqualification, it is on record, my lord.
that's right disqualification on record
It is
but
not yet admitted. And
opportunity has to be provided evidence may be late a judgment has to come
no, it is
what
before,
is what is the notice position there
it is not yet noticed, my lord.
huh?
This notice has not been issued.
notice ହେଇନି ଯଦି ତାହେଲେ disposal direction କେମିତି ଦିଆହବ
You know, the collector being a statutory authority cannot sit over the complaint, my lord. When the allegations of disqualification is evident on record.
Petitioner has a complaint under section 26 of Odisha Gram Panchayat Act pending before Collector District Magistrate Ganjam Chhatrapur since February, April 13.
No, my lord, it is 17th February 23. my lord.
17/2/23. A serious allegation even. As on date, there is no admission of such matter by way of issuing notice to the contesting opposite party. This court finds strange in the dealing by the collector being competent authority under section 26 of OGP Act. Expressing its anxiety in adopting dilatory practices in such matters, this court, however, in disposal of writ application, directly collectors and so. To undertake the exercise of admission in the election dispute case 1/2023 and also attempt to complete such proceeding at least within a period of 6 months. However, in the involvement of the party likely to be affected. Yes.
We are grateful, your lordship, deeply obliged.
item 4,
My lord, Annex 3 is pending before the opposite 2. But this is for early disposal में before the opposite 2, Lord Chief Administrator, Lord Jagannath Temple.
Considering innocuous place, annexure 3 छाड़ दो representation disposal टा कौन? Okay, annexure 3 be given a lawful disposal. It is made clear this court has not expressed any opinion on the claim of the party within 2 months.
item 5,
Five, my lord, for correction of HAL hardware have petitioner file RP case, my lord. Page 23, my lord. Page 20.
You filed RP case?
My lord.
Page 23, there is
my lord.
already order.
My lord. And
then
page 24 with the above objection in respect first page 24 the prayer of the petitioner seems justified as per HAL subject correlation, hence the claim of petitioner is allowed with the above observation in respect to the case.
ପଢି ଚାଲିଛନ୍ତି ଆପଣଙ୍କର ସାର୍ଟିଫାଇଡ କପି କାହିଁ ମ
ନାଇଁ ମୁଁ ଏଇଟା କରୁଛି 7 ଲାଗୁ ଆନେକ୍ସର 7 ର ସାର୍ଟିଫାଇଡ କପିଟା ଦେଇଛି ସେଇଟାକୁ ଚାଲ ତହସିଲଦାର ରିଜେକ୍ଟ କରିଦେଇଛି
7 ଟାକୁ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି
ହଁ
7 ଆପଣ
ସେ ଡାଇରେକ୍ସନ ଦେଲେ
ଚ୍ୟାଲେଞ୍ଜ
ତହସିଲଦାରକୁ
7 ପେଜ କେତେ
page 25
25
ମାଇଲ
Where is the certified copy of annexure 7?
ଦେଇଛି ଟ୍ୟାଗ ହେଇଥିବ ମାଇଲ ଥିବ ଫାଇଲ ରେକର୍ଡ ଟ୍ୟାଗ
ଫାଇଲ କରିଛନ୍ତି
ମାଇଲ
ନାଇଁ ମୋ ବ୍ରିଫ ରେ ନାହିଁ bring the certificate copy ଆପଣ ଫାଇଲ ରେ ଥିବ ଦେଖନ୍ତୁ ନାହିଁ
ମୁଁ ଫାଇଲ କରିଛି
ଆପଣ ଫାଇଲ କଲେ ଆପଣ ମୋ ଭିତରେ ଏତେ ଦୂରତା କେମିତି ହବ ହେଇପାରିବ କି ଆପଣ ଯଦି ଫାଇଲ କଲେ ଦୂରତା ରହିବନି
ମାଇଲ
ମୁଁ ପୁରା ବ୍ରିଫ ଟା ଧରିକି ଆପଣଙ୍କୁ କହୁଛି there is no filing of impugned order annexure 7
କାଲି ମାଇଲ ଅଛି
place this matter on Friday ଆସିଲେ ହବ ଦେଇପାରିବେ
କାଲି ମାଇଲ ଅଛି ଫାଇଲ
କାଲି କି ରଖିଛନ୍ତି ନା ପାର୍ଟି କୁ ଫେରେଇ ଦେଲେ ସେଟା
ନାଇଁ ତାହେଲେ ଥିବ ମୁଁ ଭାବୁଛି ଫାଇଲ କରିଥିଲି ଥିବ ଫାଇଲ କାଲି
day after tomorrow
ମାଇଲ
to provide one more opportunity to the council in bringing the certified copy of annexure 7
item 6,
My lord, Passover.
Passover ଆଉ ହେଇପାରିବ day after tomorrow କପି ଦେଇଛନ୍ତି ଆପଣଙ୍କୁ day after
item 7,
May please your lordship, the order passed by the sub-collector on mutation appeal is under challenge, my lord.
Revision ଅଛି କାଇଁ କରୁନାହାନ୍ତି କଣ what is that ground remand ହେଇଛି revision ଟା
My lord,
appeal is remanded only
appeal is remanded on the ground that the opposite party number 5 is one of the legal heirs of
was not involved
not involved at all. He is a stranger to the family of the
ହେଲା
petitioner.
ତାକୁ involve କଲେ ସୁବିଧା ହବ ନା involve ନ କଲେ ସୁବିଧା ହବ multiplicity of litigation ହବନି କାହିଁକି ଆପଣ
ନାଇଁ ଯଦି ତାକୁ ଇନଭଲଭ କରାଯାଉଛି it will give rise to multiplicity of litigation.
rather involvement will facilitate avoid multiplicity ସେ ଯିବ ଆଉ ଗୋଟେ suit ଟେ file କରିବ
ନା suit he has already filed, my lord.
right ଠିକ ଅଛି ତାହେଲେ participate କରୁ suit file କରିଛି ମାନେ ଆପଣ ମାନୁଛନ୍ତି ଯେ ସେଇ property ନେଇକିରି she is already in suit so how you say that she is
Nahin,
not
suit
in
for
suit
declaration, suit for petition, suit for
Sorry, Mr.
so many cases he has filed, my lord.
Mostly, your argument is negative. You are advancing a negative argument. Addition of party rather avoid multiplicity. କାହିଁକିନା ସବୁ ଜିନିଷ ଯାହାର ଯାହା ବିଷୟ ବସ୍ତୁ ଥିବ ସବୁ ଏକାଠି decide ହେଇ ଚାଲିଯିବ
My lord, in this case, what has happened? The father of the petitioner died in the year 2000.
ଶୁଣ ତାକୁ କାହିଁ ମତେ ନଉଛନ୍ତି ଆପଣ ତ ବିଷୟବସ୍ତୁ ହେଲା a party not being made in mutation comes to appeal authority and gets a remand order.
My lord.
The remanding authority says yes, non-inclusion of such party may prejudice such party. Ultimately, judgment may remain ineffective. So let there be a decision in the involvement of all parties. How that order is illegal? Withdraw କରିଦିଅନ୍ତୁ କାହିଁ ଗୋଟେ negative order ନେଇକି
Withdraw with an observation, my lord. He'll file the revision.
ହଁ ଆପଣ ସେଠି objection ଆପଣ ଦେବେ ତାକୁ କଣ observation ହବ ଏହି objection ଦେବେ ତ
ଆଜ୍ଞା
ହଁ ସିଏ ତାର application claim ଆଣିଲେ ଆପଣ ବାଧ୍ୟ ଦେବା ପାଇଁକା Yes, sir. The postal and counsel for the petitioner wants to withdraw the litigation, however, with a liberty to bring objection to the claim of the third party interest involved in the original proceeding. This court permitting withdrawal of the writ application in the event the third party in the benefit of an outcome in the appeal order, mutation appeal 83 of 21 brings any claim. Petitioner herein shall be provided with opportunity to bring objection to the same. And the outcome will also include such objection. Petitioner's court of
Item 8.
8, my lord, last division, my lord, directed to obtain instruction. I'm wrongly hold the file. So
read entertain ହେଇପାରିବନି
day after tomorrow ଟା ଟିକେ ଭୁଲ ଫାଇଲ ଟା ଗୋଟେ ଚେଞ୍ଜ ହେଇଯାଇଛି ସେଇ ନାଁରେ ଅଲଗା ଗୋଟେ ଲୋକର ଫାଇଲ ଟା ପଳେଇ ଆସିଛି day after tomorrow.
No, such a read is not maintainable.
ମୁଁ ପ୍ରେସ୍ ପରଦିନ ଥାଉ
withdraw କରନ୍ତୁ. No mandamus can be given in this way. If you have a dispute, then go for civil dispute.
Mr. Bharat Mishra, he is out of station. Bharat Mishra. What I pray on behalf of. Last time, my lord, directed to obtain instruction also. Last time, भूल file टा अलग file पड़े. They are in possession of the land, my lord, as per my instruction, my lord.
Yes, objection ପାଇଁ ଦିଆ ହେଇଥିଲା DSGA କାହାନ୍ତି
My lord, I am
yes, what is your objection?
My lord, I am appearing on behalf of my lord and senior.
You were directed to obtain instruction.
My lord, 1 week's time, my lord, required, my lord.
Central Government Council. Pari, PK Pari. Pati.
PK Pari, my lord. Virendra Kumar Pari.
PK Pari, then it Central Government Council 6. Time to bring instruction and or counter. Place this matter 2 weeks after date.
May I pray one thing, my lord? They are going to demolish, my lord. At least status quo. Status quo.
Sorry, no read is entertainable, Mr. Counsel. Yes.
Item 9.
May please your lordship, my lord. In this case, the
ଏଇଥିରେ
petition-
ଦେଖିବ ଗୋଟେ କଣ ଅଛି notes of submission filed by petitioner place. Okay, all right.
May please your lordship, my lord. In this case, petitioner challenged the order dated 27/2023 passed by the Tahsildar Bhubaneswar under rules 34 of survey settlement rules, my lord. The proceeding has been initiated on 10th July 2023 and without notice that has been concluded and disposed of on 27/2023. Rule requires the individual notice and general notice to the affected parties, and there is a minimum gap of 15 days to file objection. Nothing has been considered, and directly disposal without, though the record of right has been continued in my name, that has been deleted and is included in the government.
You are a party to such proceeding.
Man, they have not made party at all. They have initiated the proceeding initiated at page 9 on 10th July 2023. Thereafter, the final order passed 27/2023. Record of right has been correct.
Are you interested for all such properties?
No, I am only in respect of one property I have indicated in my prayer of this case.
Which
One
property?
My lord, Khata number 28701.
Khata number?
2870 by 161686.
Serial କୋଉଠି ଅଛି?
Para 78. Page 11 of top first. Page 11 of first line. 2582 by 1467, that is plot number.
2583.
No, 2582 by 14676.
2582 ଆପଣ କୋଉଠି ପାଉଛନ୍ତି? ଓ ସଭା ଉପରେ ଅଛି।
ସଭା ଉପର ଲାଇନ୍ ଟା ସେଇଟା ପ୍ଲଟ ନମ୍ବର ତାପରଟା ଖାତା ନମ୍ବର ତ ଏଟା ଏରିଆ
ସେଟା ତେଣୁ ସେଟା that's a plot in the item 1 serial 1.
serial number that is corresponding to Sabak plot number 1457.
Then who is the contesting party here?
Contesting party the state and the Swaraj board.
State.
That has been
Swaraj
included.
board, are you appearing? It's a board. Swaraj board.
Swaraj board no.
The notice has to go. Issue notice on the question of admission and fixing substitute date. Interim order କରିବ. Order annexure 1. Effect of the order annexure 1 so far it relates to land schedule. Item 1. Village Andharua, item 1. Sabik Khata number 579. Sabik plot number 1754, Hal plot number 2582/14676. Extending 0.030. There shall be status quo in the spectre. There shall be, okay. When I लिख लो there shall be no effect of the judgment subject to it. It is top of the error, page 11. Right. Till next day.
Item 10.
May I please, your lordship. Lordship, this is a matter where we are challenging the inaction of the collector, my lords. We have filed a petition seeking correction of ROR and handing over
But
the property.
how the collector will enter into demarcation exercise?
My lords, may kindly see what we are seeking is just to restrain because the erstwhile Vesco and
You want demarcation or not?
no, my lords, I just want my properties to be which I have retained. There was an accession agreement way back in 1947. My grandfather was an ex-Raja rural of the Dominion of India, and there was an agreement with the Dominion
Make
of
it
India.
clear what is your purpose. You want demarcation or not?
My lords, may kindly issue that demarcation and that no permanent structure be built upon.
Who is undertaking permanent structure?
My lords, TP NOTL, erstwhile Vesco.
Erstwhile?
Vesco, my lords.
Nesco.
Vesco. My lords. We have, my lords, since
Then where is
annexure
if you
5
have a grievance against it,
annexure
why
5
do you involve the collector? Is it your personal land?
My lords.
Then why don't you go for civil right?
My lords, the point being is we have retained these lands.
Sorry.
My lords, may kindly see the annexures. My lords, your lordship may be clear.
Sorry.
My lords, may kindly only protect me. My
Sorry,
lords.
you withdraw or else I'll dismiss.
My lords, may kindly see my bona fides too, my lords.
No. Looking to the nature of litigation. This court finds there is private interest involved herein over disputed property. In this circumstance, this court finds there is no scope entertaining the request by way of a writ application. Party, if so advised, may approach competent civil court.
Milords may protect me, Milords. That's my humble submission that.
Yes, next.
Item 11.
The petitioner is seeking for a direction to the opposite party number 3, Tahsildar
Your
Baranga.
demarcation
My
procedure
lord.
pending.
My lord.
What is the number of the case? Where do you find demarcation case pending?
My lord. Can you see annexed to page 41, the petitioner deposited the
41.
case, my lord. My lord.
Through document page 41 annexed to 2, it has been brought to the notice that there has been pendency of a demarcation proceeding. Pending before it is the
Opposite party number 3, my lord.
Huh?
Opposite party number 3, Tahsildar Baranga.
OP number 3. Okay, all right. Hold on. This court disposal of writ observed in the event there is already bringing in a demarcation proceeding through annexed to the OP number 3, na?
My lord.
3 is directed to conclude such proceeding, however, proceeding involving higher plot number so prayer. However, involving the parties likely to be affected by completing such exercise within a period of 2 months from the date of communication of order.
Okay.
Yes.
Item 12.
12 देखियो.
May
12
I-
ଆସିଲେ
may
after recess करो.
After this.
Hurry. I have stopped listing any further content.
My lord, pending since 2022, my lord.
Maybe. Sorry, yes, next.
Item 12.
There will be no listing of any content matter. State Council, I am also making it clear till my retirement, there will be no listing of any content matter. This can wait. Anybody else will take what is there now. I'll only finish some fresh admission matters. That's all. No final hearing. Council, if any sitting in final hearing, may leave the court. No final hearing henceforward.
Item 12, my lord. May I please?
Wherever interim orders are there, will be allowed to continue.
This
Yes,
matter,
item 12, Mr.
the
Sotto.
land acquisition proceeding was initiated and it was referred to the civil court.
Pardon?
The land acquisition proceeding initiated was referred to the civil court.
Hmm.
The referral court, my lord, what has done, it has advanced at so much and put up the matter for the Lok Adalat. And in Lok Adalat, my lord, the illiterate person, my lord, he signed and it's compromised. My humble submission before my lord is that this compromise entered in 2017 and they have paid the amount in the year 2013, April 2013. And after other referral cases are disposed of. So I have been discriminated by taking the lower amount.
Last occasion, a point was made out.
Yes.
That in the usual proceedings, there has been
other cases
better
disposed
payment,
of.
towards compensation.
I have annexed one document.
Whereas in the Lok Adalat, there is lesser payment. Therefore, I had directed State Council to see if there is any discrimination or not.
I have not examined.
Not.
My lord, one more submission, my lord. Recently, I have got a judgment of the Honorable Supreme Court. It says, my lord, if there should not be any discrimination.
No, that you have shown on the other day.
Another
But unless I interfere in the order of the Lok Adalat, can I pass a order?
No, my lord, then, my lord, your lordship, my only submission for lordship, I will take a step before the civil judge
let the civil judge taking into consideration all my pleadings before your lordships.
In the existence of
Make a
order,
make a relook. I would like to take your lordship.
how you within what parameter? Or you'll bring a review.
No, review there is
114 review may be there.
no scope, since it is in Lokadalat, so I have no.
So therefore, I am to set aside. Unless I set aside, you don't get any other scope. You don't get any other scope. Mr. Sahu, there is no question of taking instruction from party.
No. I have personal not examined.
He has filed the civil court judgment benefiting people.
Yes.
Better than this man, he has also filed the copy of Lokadalat order.
Yes.
And he is giving copy of this judgment. Examine, we can take a decision on that.
And hardly
so Friday.
Friday no asu, Sombar asu.
But a copy.
Monday asu, Monday.
How
Then Thursday, your lordship, keep it
Tuesday more band baja barat.
keep it to Thursday.
No, how Tuesday,
keep it to-
Monday more.
keep it to- keep your lordship.
Monday I may see for some time. ଦିଅନ୍ତୁ ତାଙ୍କୁ ସେ
How the judgment is ଦେଇ ଦଉଛି.
କପିର judgment ଦିଅନ୍ତୁ. Simple question involved here in
Thursday, your lordship.
as to the for larger benefit through the normal disposals in civil in section 18 proceedings. Can the petitioner be prevented from getting can forced to get the benefit through a local adalat at a lesser side. Lesser side. Satpathy also brings on record a judgment of Hon'Ble Appeals Court. କୋଉଥିରେ ଅଛି ଆମକୁ କପି ଦେଇଛନ୍ତି?
ମୁଁ ଦେଇ ଦଉଛି ରେଫରେନ୍ସ ଟା ଲେଖିଛି
ରେଫରେନ୍ସ ଲେଖିକି ଦିଅନ୍ତୁ.
ମୁଁ ଦେଇ
and a copy ବି ଦିଅନ୍ତୁ.
କପି ମୁଁ ଦେଇଛି. I will supply.
So and so. State Council wants to go through the Apex Court judgment and submit on the next date of posting on Thursday. This is the point of law. There is nothing else.
Yes.
So party ro involvement भी किसी दरकार नहीं. In that case, what will happen? Maximum, I may set aside the local adalat order and remit the matter back for considering in the light of the other civil
revisit, yes,
proceedings. Maximum.
31st, your lordship. Thursday, 31st.
Thursday.
That's okay.
13.
Madam, Annexure 3 is pending for opinion 2. The same has not yet been registered or taken up, madam. My only prayer.
3 is a proceeding.
Madam.
In a dispose of proceeding.
Yes, madam. Registration has been filed since 8/5/2000.
Prayer court for the pendency of the proceeding by Annexure 3. Claimed herein, this court disposing the writ application direct the
Opinion number 2.
Settlement officer, Major Settlement Office Jopra for giving a lawful disposal to the miscase involved in by completing entire exercise within a period of 2 months, however, providing opportunity to the party likely to be affected.
Item 14.
May I please, your lordship. My lord, Annexure 6 is under challenge, my lord. The learned election tribunal has rejected my application on the ground of res judicata, your lordship.
No, application for what?
Application for calling for the rejected votes for scrutinizing, my lord.
Res judicata means, was there any previous application?
Previous application was filed for calling for entire votes, which has been rejected earlier. Now I am paying for only the rejected votes for scrutinizing.
You are the election petitioner?
Yes, lordship.
All right, issue notice on the question of admission. Fixing short returnable date, matter be placed immediately after appearance of the contesting opposite party. 2 extra copies be served on State Council, who will be representing the state parties. Requisites as undertaken by day after tomorrow. In the meantime, there shall be stay of further proceeding in election miscase 1 of 22. नहीं out till next date करनी पुनी का पाके आसीबो न आसीबो in the meantime से तो election petitioner आछे कोर्ट को ताका petition से स्टे करी बसले हो Next.
May I please, your lordship? My lord, annexure 3 of my representation pending before the opposite party
Yes,
number
yes.
3.
Prayer quote karo on the self same
Three,
issue
four.
it appears. Annexure 4 is pending before OP.
3, 4 and 5.
4 and 5 in such event, in the disposal of writ application, this court direct OP number 4 and 5 to take a lawful decision on the annexure 4 hearing, answer 4 and 5 hearing.
2 and 3, my
Huh?
2 and 3,
2
opposite
and
party.
3, right. Hala. This court at least the giving necessary exercise at least within a period of 1.5 months. From the date of service of copy of the order.
Obliged.
Item 16.
My lord, my residential house standing over the scheduled plot remained unsurveyed. Page 47, as per lordship's earlier order, the sub-collector come settlement officer, in paragraph 2, page 47.
Yes.
On the basis of the configuration as shown in trace map and report, the head draftsman has suggested to record the unsurveyed area and to include the same with the final plot number 81 and to be recorded for an area 14
This
decimal.
is a 37-1 proceeding.
हाँ मत एटा परे भी सेटा को रिजेक्ट कर लिखि देले I have no power.
Pardon?
The assistant sub collector giving such
This
observation.
is the direction in the manner of preparation of the record of right.
My lord, the page 48, so liberty was given to because final publication of ROR revision lies to under section 37 consultation page 48. So
Yes.
having been obtaining the liberty, I filed a revision page 49. So the impugned order page 51 and 52. So without the findings of the settlement officer, so detailed inquiry was being conducted by the head draftsman. So they admitted that the 7 decimals was remained unsurveyed.
Private party is there.
No, private party की नहीं जेहेतु unsurvey है ही नहीं सेठो
Already issue notice on the person.
এটা survey ही नहीं simple mistake.
Item 17.
17 lordship, covered matter lordship.
No, I have a few objections, my lord. Here, my lord, my learned friend is relying on the judgment rendered in Narottam Ratha's case, my lord. So,
Case ଟା କଣ ମୁଁ ବୁଝେ ଆପଣ ସବୁ jump କରିଗଲେଣି conclusion.
ठीक ଅଛି କୁହ.
Here,
What is his prayer?
My prayer is I have filed and proposed miscase before the ASO to accept my the miscase and correct the involved the judgment passed by the in the case of let's say judgment passed by the Hon'Ble court in case of
Right, Mr. Ghosh, what do you say? Why his application will not be entertained?
No, application that is normal. What he will be getting no relief before the ASO because background.
He can't also show any order showing any relief. My order covered means I have said
Yes,
in the event any such application is brought, it will be considered.
Yes, that.
But however, keeping in view the judgment of the Supreme Court reliable or not. That's all.
Narottam case.
They ହିଁ order ଦଉଥିବେ ସିଏ ଆଉ କଣ ଦେବେ? हाँ same ସେ ଯୋଉ order ହେଲା ଏଠି annexure 7 ଟା. He is declining to accept the annexure 7.
Yes, sir. That is my whole.
ସେ difficulty ଟା କଣ ହେଇଛି ସେଇଟା ଖାଲି ମୁଁ କହିବାକୁ ଚାହୁଁଥିଲି ସେଇ ଫାଇନାଲ ପବ୍ଲିକେସନ ଯେହେତୁ ସରି ଯାଇଛି ଏମାନେ ସବୁ ଏବେ ଆସିଲେ ସେଇ ରିଟ୍ ରେ ଯୋଉମାନେ ସବୁ ପିଟିସନ ଆସିଥିଲେ
why you are laboring so much? Why you go to the ultimate end now at this stage?
ଠିକ ଅଛି.
He simply brings an application.
ହଁ ତାକୁ ସେ କନସିଡର କରିପାରିବ
not entertainable, it is the adjudicatory authority to adjudicate. ଆମେ କାହିଁ ଏ ସବୁରେ ପଛୁଆ? Somebody has a civil litigation or a revenue litigation. He is approaching somebody. Yes. Prayer quote karo lekha without entering into controversy as to whether there has been illegal declining of accepting the miscase by annexure 7, this court however in the disposal of the writ application, direct opposite party number 3, the ASO rental colony Jobra, to accept the application by annexure 7 if it is tendered by the petitioner at least within a further period of 7 days, and take a lawful decision on the same, however, keeping in view the applicability of the judgment of this court in WPC number 1608 by 2014 and batch matters in the case Narottama Ratha versus State of Orissa. Let the petitioner submit the application afresh along with the copy of judgment of this court in Narottama Ratha Supra.
Obliged, Lordship.
Item 18 also
18.
same. Also
Same.
similar.
ଏଠି କୋଉ application ଟା
Application annex.
ସେଠି ତ annexure 7 application ଥିଲା ଏଠି କଣ application ଆପଣଙ୍କର refuse ହେଇଛି କୋଉ annexure
Accept କରୁନାହାନ୍ତି. Accept କରୁନାହାନ୍ତି.
କାଇଁ ଏଠି ଦେଇଛନ୍ତି
Annexure
ସେଟା ନା
5.
ନାଇଁ
Annexure 6.
ତାହେଲେ annexure 7 ଲେଖିବନି ହେଲା
Annexure 6 ଏଟା.
6 ଟା ତ ଏଠିକାର ହାଇକୋର୍ଟ ଅର୍ଡର ଟା
ନାଇଁ ନାଇଁ.
annexure 5 6 କେତେ page
6 at
48.
48.
okay
Jadi
ଏଠି
proposed
annexure
miscase.
6 ହବ ସେ 7 ଜାଗାରେ 6 ହବ ଆର କେସ୍ ରେ 7 ଡକା ହେଇଥିଲା ଏଟା annexure 6
Others are similar. Others are similar. Others are similar.
ହଁ same right ସବୁଥିରେ annexure 6 ଅଛି ସବୁଥିରେ annexure 6
ସେ annexure type ଅଛି
ଗୋଟା ସ୍ଲିପ ରେ ଲେଖିକି ଦିଅନ୍ତୁ କୋଉ କେସ୍ ରେ କେତେ annexure yes
Item 19.
Well, 19 on behalf of Mr. Bera. Well, your lordship cover order melod annexure 2 kindly.
କପି ଦେଇଛନ୍ତି
yes page 10 order you are referring
Yes,
page 10 order
with melod with matter is same. With matter melod. Second matter.
ତ ସେ ବି ହବ
Yes.
ହଁ right
Item 20.
Under revision petitions are pending for admission. not
Fresh
yet
admission?
admitted. My lord.
right
Obliged.
Item 21.
May I please, Your Lordship? My lord, in this writ application, the petitioner is praying for a direction to the Tahsildar Balia for settlement of Bhutan land.
21 ଟା ପଳେଇଲା କି just 1 minute
କପି ଦେଇନାହାନ୍ତି
For settlement of Bhutan land.
ଦେଇଛି ଆପଣଙ୍କୁ କପି ରିଟ୍ ର କପି ଦେଇନାହାନ୍ତି
ପୂର୍ବରୁ ଦେଇଛି।
yes prayer court କରିଦିଅ ଭୁଦାନ ଦଉନାହାନ୍ତି କପି ଦିଅନ୍ତୁ right all the 3 cases
ନାଇଁ
right
କିଛି କହୁଛୁ ଆମେ ଫାଇଲ୍ କରୁଛୁ
Kaka next.
ଡେଫିନେଟଲି କରୁଛୁ ଆମ ଅଫିସ
Item 22.
It's an application. Impugned order is annexure 1, page 11 is under challenge, Your Lordship. Here, what happened? Earlier, the present petition was earlier approached before this honorable court seeking for direction for early disposal of the Bebandotho status case number 72 of 2020. That order was found place, Your Lordship, page 36, Your Lordship. Page 36, in the brief. Your Lord. That order was passed in 7/12/2022, directing the for conclusion the Bebandotho status case number 72 of 2010 at least within a period of 4 months.
Right. Thereafter, what happened?
That order was passed in 12, but what happened? Now I have given the notice was issued in the under annexure page 38, Your Lords. Page
another proceeding.
Another case notice issue kale kariki backdate order kar dele. That is annexure 3 series, Your Lordship, page page Your Lordship.
କଣ ହେଲା
ସେଥିରେ ସେ notice issue kale 72/2020 ରେ notice issue kale ମତେ apparent date ଦେଲେ 22/11/2020 Lordship. Kindly glance for 3 series ରେ ବାମ ପଟେ ଦେଖାଉନି ସେ date ଟା
କୋଉ page ଦେଖଉଛନ୍ତି
ସେଇଟା ହଉଛି annexure 3 series, Your Lordship.
page
କେତେ
29, Lordship. ସେଥିରେ ମତେ notice issue କଲେ
this is pursuant to the High Court direction.
prior to the direction of the High Court, Honorable High Court's direction. Lordship.
କରିଦେଇଛନ୍ତି ତାହେଲେ କଣ
ସେଇଟାରେ different case Lordship. That order was passed in ମତେ notice କଲେ 72
ନୋଟିସ ହେଲା କଣ ହେଲା ଏଥିରେ କିଛି ହେଲାଣି ଆଉଟକମ୍
ସେଇଥିରେ ସେ କଣ କଲେ ନା annexure 1 kindly glance for a moment. That order was passed in 2017 order ଟା କରିଦେଲେ ସେ ମତେ notice କଲେ 22/12/2020 ରେ appearance କରିବା ପାଇଁ ଦେଲେ 72/2020 ରେ appearance ପାଇଁ ଦେଲେ ମୁଁ ଏ କେସରେ
appearance କେତେ ତାରିଖ କୋଉଠି ପାଉଛନ୍ତି
ସେଇଟା ଯେ ଲର୍ଡସିପ ପେଜ ବାମ ପଟେ ସେଇ ପେଜ ର 29 ରେ ଟିକେ ଜଣା ପଡୁନି ବାମ ପଟେ ଏ ଲର୍ଡସିପ 22/10 ଲର୍ଡସିପ ମାନେ ମୋର annexure 1 is passed behind by pay lordship. That is my whole submission lordship. Without hearing to the present petitioner lordship that order has been passed
22/11/20
lordship
ହଁ ତାପରେ କଣ ହେଲା
ସେଥିରେ ସେ ନୋଟିସ ଦେଲେ ମତେ ବେବନ୍ଦୋଷ କେସ୍ 72/2020 ଟପ ରେ ମେନସନ ଅଛି କେସ୍ ନମ୍ବର ଟା କିନ୍ତୁ ଏଇ ଯୋଉ ଅର୍ଡର ଟା ପାସ୍ କଲେ annexure 1 ରେ ପେଜ 11 ରେ ସେଟାରେ ମତେ ଅପରଚୁନିଟି ଅଫ ହିୟରିଂ ମତେ ନ ଶୁଣିକି ସେ ଅର୍ଡର ପାସ୍ କଲେ 30/11/2022
so you challenge annexure 1
yes lordship that without hearing to the present petitioner lordship
annexure 1 ର certified copy କାଇଁ ଅଛି ହଁ ଅଛି already expert in nature କହୁଛନ୍ତି notice ଯାଉ
ଆଜ୍ଞା
notice what interim order you want
now the what happened total all the lands
ତାଙ୍କ notice କଲେ ହଁ
status quo in respect of the disputed land as on date be maintained
status quo in respect of position lordship. I mean all your
ଠିକ ଅଛି ତ status quo ହେଲା ପାଇଲେ
obliged.
Item 23.
23, my lord. My application is pending before the passport authority regarding renewal of the passport, my passport.
application
Annexure 2, my lord.
ଆପଣଙ୍କୁ କିଛି ଖବର ଦେଇନାହାନ୍ତି
ନା
ଆସନ୍ତୁ ଅମୁକ ତାରିଖରେ ହାଜର ହେବେ କଣ ହେବେ ନାହିଁ
କିଛି ନାହିଁ ସେ ଗୋଟେ ଖାଲି ଇନକ୍ୱାରି ରିପୋର୍ଟ ମଗେଇଥିଲେ ଥାନାରୁ ସେତିକି
ମାଗିବେ ତ
No, my lordship may come to the page.
ତାପରେ ଆଉ କିଛି ଡେଭଲପମେଣ୍ଟ
Lordship may
ହେଇନି
come to the page 15. Annexure
2
3.
series is your application
2 series online application.
it's a
May
party
I audible, my lord?
yes
Yes, my lord. Lordship may see a page 15.
1
Page
5
15. Yes.
yes page 15 you were asked to appear in between 10 a.m. to 2 p.m.
Please attend this office inquiry with online appointment.
why are you not
with
appearing and why
requisite
are you coming
document.
to High Court why are you not appearing and why are you coming to High Court I was asking you this question only they usually communicate yes had the submission of respective counsels petitioner brings the writ application under the allegation that application annexure 2 is not given any outcome annexure 2 the application annexure 2 for this is fresh passport or renewal renewal of passport involved therein has not been given any outcome the party however and a suitable direction be given by this court for early outcome in the application pending at the instance of the petitioner. The party run at DSC. However, on the other hand, taking this court to document at page 15, annexure 3, submits there has been already notice to the petitioner on 6th December 2022 to attend the office of the regional passport officer with the desired information and documents therein. The party alleges, in spite of such an opportunity, petitioner instead of attending the office of the regional passport officer, unnecessarily troubling this court.
Liberty to appear, madam.
It is in the circumstance this court find. In the event there is no final outcome on the passport application, renewal of passport application of the petitioner, and the issue is still pending consideration, it may be open to the petitioner to respond to the passport office through their letter dated 6th December 2022 to enable the regional passport officer to take a lawful decision on the same. It is clarified in the event there is any criminal case pending involving the petitioner, it shall also be open to the petitioner to produce bail order, if any, before the authority for his consideration and taking a lawful decision there.
Hon'Ble.
Yeah, Joteshwar na likhido.
Joteshwar Naik is appearing with me.
Yes, he is standing here. He is standing here.
Similar order, my review
Yes,
application is similar order given. The review application pending OP 2000. Connected 3 connected similar. All are similar.
Item 25.
All are similar.
Item 20.
Connected के similar man. Connected के similar.
Connected cases 24 रे so
କହିବା ଦରକାର ନା?
May I please your lordship? May I please your lordship?
Yes.
Item 25.
Yes.
In this case, the petitioner has preferred the present rate application, challenging the order passed by Land Commissioner Consolidation Cuttack OP number 1 at Annexure 1 for passing arbitrary orders without taking into consideration the judgment passed by Deputy Director.
1 minute. Have you filed the certified copy of Annexure 1?
Yes, your lordship.
No. I don't find certified copy.
Page number 8.
No, case number there. There is no issue in that. Consolidation revision petition 54 of 22, page 7.
Yes, your lordship.
Page 7, 8 and 9. These are the orders. Okay.
Yes,
Where
sir.
is the certified copy? Please find out you might have copy with you.
No, your lordship, I don't.
Then you have to bring that unless it's a revision order. Proceeding will not be maintainable. How much time you require?
2 days time.
But young counsel, you should not file a writ application in absence of a enclosure of certified copy of the impugned order.
Your lordship, I had
This
submitted
is
the
happening regularly.
certified copy. I guess the original one must have gone to the government side.
Original will definitely be with the revisional authority. There is no doubt, but you must get a certified copy to
Yes, sir.
challenge that.
Yes, your lordship.
Original, it is quite usual. Why should they give the original? Original remains in the file. ଆମେ ଏଠି ଯୋଉ କରୁଛୁ ଆମେ କଣ original ଟା କାହାକୁ ଦଉଛୁ?
Yes, your lordship.
କେତେ ଦିନ ସମୟ ଲାଗିବ?
2 days.
2 weeks.
2 days.
2 days, all right. Place this matter on Friday as the counsel for petitioner wants to bring on record the certified copy of Annexure 1 by this time. Bring
Okay.
it.
Item 26.
My please, your lordship. Lord petitioner's limited prayer Miller has filed objection case in 2013 Miller. The notice is at Annexure 3, page 29.
Objection cases are pending. Objection cases means section 9 proceeding.
No, Lord, after draft publication, the objection was filed in 2013. Thereafter, Miller, the notice was issued. This is the last notice, Miller, to appear on 26/8/2019.
All right, Innoco's prayer there, all right. Like a writ involved following prayer, considering Innoco's prayer. This court in disposal of writ application observes in the event the objection case number 1307 of 13 is still pending. Same may be given a lawful disposal, but however providing opportunity of contest to parties likely to be affected.
Obliged.
At least completing such exercise within a period of 4 months from the date of communication of order.
Lord, in the meantime, they are going to publish the final order. Your lordship may say.
Cause of action is that means the objection has been already taken into account.
No, it has not been, Lord, after.
Then if it is not disposed, how there is final publication?
Lord, they are going to make final
No, they are
publication.
going to means they have
Yes,
taken the
but
exercise.
it is their statutory duty to dispose of the objection case prior to that.
That's why I said if it is still pending, you will be given opportunity.
My lord, obliged.
Final publication ହେଇଗଲେ ତ ଆଉ ଗୋଟେ stage କୁ ପଳେଇବ.
Aye.
So
Item 27.
May I please, your lordship? In this case, my lord, the revision case was allowed on ex parte. Thereafter, I filed a miscase to set aside to that order, my lord. That was rejected.
Annexure 6 is rejected.
Annexure 6, my lord. Please, my lord, it starts from 35.
Private parties are there also.
My lord.
Where is the rejection order?
Page 35.
Okay, 35.
35, my lord.
All right, so notice on the person of admission is sorted. Refugees has undertaken manner of refugees Cordova and miscase notice also notice there shall be miscase ଟା ହଉଛି ଗୋଟେ ହଉଛି exemption of annexure 4 that is allowed for the timing. 13128 is stay of operation of order annexure 4 and 6. Okay. In the meantime, there shall be status quo in respect of the disputed property till the disposal of the application.
Obligation.
Item 28.
My
My lord, a small prayer, my lord. In this case, what happening? The Tahsildar, the court has directed to Tahsildar to take steps for the mutation, my lord. That may be stopped, my lord.
Step
For mutation.
mutation. That's why I said status quo in respect of property.
Well,
It is only preparation of a record.
well,
So status quo maintain hele third party interest
Third-
ହେଇପାରିବନି.
ହେଇପାରିବ.
It is bigger as a outcome rather.
Item 28.
May I please, my lord? My lord, this is covered by your lordship's order, my lord.
Yes, Mr. Ghosh covered. Right.
Obliged, my lord.
Item 29.
May I please, your lordship? Here the
Let us
petitioners
simplify
before your lordship, the challenge has been made in the annexure 4, your lordship, the order passed in 2002, your lordship. Here the case, your lordship, annexure 1, page 15, your lordship, kindly have a glance.
1 minute. Annexure 4 is a order in 15B.
My lords.
And you also challenge annexure 6.
Yes, your lordship. Subsequent, in view of the order passed in annexure
Don't
4.
run away. I just find, I don't
Yes,
find
yes.
the certified copy of these orders.
Yes, your lordship, that is there.
That is there.
Yes,
କୋଉଠି? ଆପଣଙ୍କ ଫାଇଲରେ ଅଛି ମୋ ଫାଇଲରେ ନାହିଁ.
sorry, my lord. Yes.
Find out if you
Yes,
are
yes,
keeping
yes.
that copy,
Yes,
retaining
sir.
in your file. ଆପଣଙ୍କ ଫାଇଲରେ ଅଛି କି?
Yes, your lordship.
ଅଛି ଯଦି ଆଣନ୍ତୁ, bring on record.
ଫାଇଲ କରନ୍ତୁ sir.
ଗୋଟେ memo ଦେଇ file କରନ୍ତୁ.
My lord. କାଲିକି ଆସୁନ ଆଜି
Day after tomorrow, in the meantime, certified copy of annexure 4 and 6 both be on record.
My lord.
କାଇଁ ଆପଣ ପାଖରେ କାଇଁ ରଖି ଦଉଛନ୍ତି?
Item 30.
May I please, your lordships? But OP number 4 is the contractor under my lord. OP number 2 and 3.
Pardon?
OP number 4, your lordships, was the contractor before OP number 2 and 3. He executed the work and half work he could not be executed. Therefore, my lord, he executed one agreement with me and write a letter
You
to
are
FCM.
you are a contractor under OP number 3 and 4.
OP number 4, your lordships.
OP number 4. Who
OP
is
number 4 was a contractor under OP number 2 and 3, that is MCL.
2 and 3.
My
2 and
He
3 are
could-
Mahanadi Coalfield.
my lord. He couldn't, my lord, execute the work due to bankrupt. Therefore, he allotted the work to me and wrote a letter to OP number 2 and 3. Your lordship may kindly see annexure 3 for a moment, page 43.
Annexure
3, page 43. He said, the MCL may be permitted me to execute the work.
Just page kete?
43, your lordship, 4-3.
4-3.
My lord.
Yes.
My lord, to give permission to me, my lord, to the petitioner, my lord, to execute the work, and 90%, my lord, of the work amount should be deposited in my account. The petitioner was allowed to work, my lord, but deposit was the disbursement of the money of that said work of 6 crores 55 lakhs was not given to me. And in the meantime, my lord, step is taken to disburse that money in favor of OP number 4. He is of Madras, and all the machineries and all these things which are kept are allowed to leave. Now there is no possibility, my lord, to get the money.
What is the terms in agreement on payment aspect?
The payment, my lord, that is, my lord, at 43, my last portion. 90
No, 43, all the terms and conditions of agreement will be complied by the subcontractor.
My lord. And 90% of running on account bill against the executed work by the petitioner, private limited, should be deposited in the bank account of the petitioner.
This is by your firm.
No, my lord.
The firm who has authorized you.
My lord, that is OP number 4. OP number 4.
OP number 4.
My lord, who was initially the contractor. He has written to the MCL authorities, my lord, to give me.
Yes, that's right.
My lord.
This was the contractor who was initially provided with the work.
My lord,
Now he has transferred the work to you.
you, my lord.
Where is the consent of the management?
But here, my lord, this letter was issued by OP number 4 to MCL authorities to give me permission to
Oh,
execute
he
the work.
writes then, are they obliged?
But they have, my lord,
Where is the
the
transfer?
person to annex.
Mr.
My lord.
Mahapatra, you have to satisfy that yes, there is a valid transfer of the contract.
My lord, by this letter.
Contractor writes something, management is not obliged.
But this is, my lord, the letter which has been
Sorry.
issued, my lord. This is the letter. My lord,
Sorry, that's a contract between you and OP number 4. If there is violation of that, then you have to approach under appropriate authority.
No, my lord, my humble submission before lordship. Your lordship may again kindly see Annexure 3.
Huh?
Annexure 3 gives two, my lord, two ways.
Yes.
One way is, my lord, to give me permission to execute the work. Second is, my lord, to deposit the money in my account. Pursuant to this letter, I was allowed to work, my lord.
Annexure 2.
Annexure 3, your lordship.
No, no,
43.
Annexure 3, we don't understand. I at least don't understand.
My lord,
this.
Annexure 3 gives the two
No,
pictures.
sorry, unless you show that there is transfer of the work from OP4 to you. You don't have right to
Oh,
come
yes,
to
my lord,
High Court.
That is, my lord, Annexure 3, my lord.
Annexure
Annexure
3 is
2,
not.
Annexure 2, my lord. Annexure 2 is the agreement which is executed by OP number 4 in my favor. Annexure 2.
Annexure 2.
My lord, Annexure 2 is the agreement, my lord, which has
So
been
agreement is the MCL signatory to the agreement?
here, my
That
lord.
must not be.
No.
That must not be.
So by executing this,
Sorry.
my lord, your lordship may kindly,
Sorry.
your lordship may kindly.
Sorry, I don't waste my time in
My
this
lord,
way.
whenever this agreement was executed, thereafter, my lord, Annexure 3 was, my lord, made.
That's right.
Annexure
Therefore, you go to.
And then, my lord, MCL authorities allowed me to do
Sorry,
execute the work.
withdraw or I will dismiss.
Your lordship may keep it to next week so that, my
Huh?
lord, your Annexure 4 is pending, your lordship may
Sorry.
say. Annexure 4.
No, I will not. It
The
is not by
representation
it is not by OP4. It is by you only.
No, Annexure 3, my lord, 4.
Sorry, I don't find any ray of relationship between you and the MCL.
My relationship, my lord, I was allowed to work, your lord.
Had this court considered the grounds.
But Annexure 4 may be disposed of, my lord.
Huh?
Annexure 4 representation I have filed before.
Sorry,
the MCL.
representation by outsider cannot be directed to be disposed.
But I have filed before the MCL authorities, your lordships.
You might have filed. Who are you? What is
On
your
the
locus standi? What is the relationship between you and MCL?
MCL,
You
my lord,
can't just go on making some application.
I will show that, my lord. I will show that documents. Your lordship may kindly.
Pardon?
I will show those documents, my lord, the communication between MCL authorities
Place
and
the
myself.
matter 1 week after.
Next week, your lordship may say.
As there is no document to establish at least any connection in between the petitioner herein and the MCL authority. Further, MCL authority has any authority authorizing the OP number 4 in the transfer of work assigned to OP number 4 in favor of the present petitioner. The Mahapatra Learned Counsel appearing for the petitioner seeks some time to bring in amendment to the writ application. Okay, stands adjourned to 10 days. Will be listed only after any amendment application is brought on record. Yes.
Item 31.
Your struggle should have been before filing the writ application, not after filing the writ petition.
But I thought that
Once
Annexure 3
matter
will.
comes to court and then court will put certain query, now you will try to set the
No,
brief in
my
order.
lord, my
What is
impression
this?
was Annexure 3 will suffice.
You are
the
not in
program.
that age, Mr. Mahapatra.
My
You are
lord, I'm
sufficiently
sorry for that.
experienced.
But I thought that, my lord, Annexure 3 will suffice the program.
Oh, yes,
It
Annexure
gives-
3 doesn't breach any relationship.
But I was allowed to work, your lordship.
If you still argue on that, I dismiss the matter.
I'm sorry, my lord. I'm sorry.
It appears you are still to understand
My lord.
the issue.
I'm sorry.
Limited grievance of the petitioner. The collector, in pursuance to the Honorable High Court's order, passed an order. I filed a review application. My sole contention to consideration of that
Review
review.
has been also rejected.
My lord, representation rejected.
The review order.
Order is at page 33.
That is the order of, on the representation. Thereafter, he has filed a review.
Where
We
is
have
this
not-
review order?
Review order is not there. I only want consideration of that review.
Okay, all right.
That is
Innocuous prayer court innocuous prayer involved within. This court direct the review application of the petitioner by Annexure 5 pending before collector Kendrapada be given lawful disposal Okay, at least completing such required exercise within a period of 4 weeks from the date of communication of order along with copy of the
Item 32.
May I please your election petition,
Mike to Sadadantu.
election petition, my lord.
Pardon?
Election petition has been filed. I am the winning candidate petitioner. I filed a petition under order 16 rule 6 that has been rejected without assigning any reasons, ma'am. I have called for certain documents. At page 41, it is there.
What was that application?
The application is that for calling of the document pertaining to
Production of record.
production of record.
That is annexure 5. Then you have also an application annexure 6 order 7 rule 11.
6 I am not pressing that because
That you are not pressing.
because I have
Then what has been done on this calling for record?
sir, simply there has rejected in a one-line answer, page 41, the documents as called for by the respondent
This
number
by
1
impugned order, both the applications have been decided.
decided. In
Both the applications.
both the applications. That's why I.
So you press impugned order only so far it calling for record.
Yes, ma'am.
The first part of the order.
Yes, ma'am.
Who are you? Election petitioner or return candidate?
Written. I'm the winning candidate, written candidate, ma'am.
You are the return candidate. What is the position of the dispute now? Acha, just 1 minute. Before that, what is the record you want to call for?
Record is that her caste certificate.
Come to annexure 5. What is that record you want to call for?
Record is with regard to the caste certificate. She has
Produce the entire election process paper of ward number 6 and to give evidence on behalf of respondent number 1.
yes, because she has filed her nomination in 2017 as OBC. Now she is coming up saying that I am SC. This seat is reserved for SC. I am a SC.
Where is your written statement?
It is annexed 2.
Has it got any connection with this calling for record?
Yes, my lord.
Just read through that paragraph.
Page 24, my lord.
Yes, 29 probably, double S. 29 is the double S.
29 is the WS to the counter claim.
Okay, then 22.
22 is the written statement along with the counter claim. Combined
22 is the double S.
WS.
So where have you where you have this pleading
Para
to
10,
support calling for such document? Because you will next now pray there shall be stay of the further proceeding.
Yes, ma'am.
So bring me to that pleading to support calling for such record.
19, my lord. Page, para 19, page 26.
Para
19, page 26.
19.
Unis.
Yes.
That the respondent number further submits the petitioner is not eligible to contest the election which was held in the year 2022 for the post of Samiti member of Gaba Gram Panchayat, which was reserved for SC/SC. The petitioner is not belonging to the category of SC woman, rather she is a Pano Christian. That the petitioner has married to a Christian as per the Christian religion. So and so forth, man.
Then why you want entire election process? You can just seek the nomination. You say she doesn't belong to SC/ST.
Yes.
So nomination paper can only alone satisfy.
Yes, but that may be.
पूराटा लिखिले से reject कर देवे definitely.
That may be.
What is the stage of proceeding?
It is posted for hearing.
Huh?
For hearing, I think.
For hearing, so that means evidence is already.
No, evidence is there. Evidence has to be led.
Evidence election petitioner over.
No, over here. Start over.
Comments କରୁଛି. All right, issue notice on the question of admission fixing short returnable date. Okay, requisitions kardava and miscase re karo, let the evidence let there be progress in the evidence from both sides. But there may not be closure of the evidence without leave of the court. Matter be placed immediately after appearance of the petition, election petitioner hearing. Yes.
Item 33.
May I please, Your Lordship? Your Lordship, this is a case covered by the issue laid down by this court, Your Lordship. Section 22 of the OLR Act is not applicable for Gharbari land belonging to STSC plot, Your Lordship. The registering authority has rejected.
All right. Sub 2 copies, upon low copy, upon dekho to it cover ki.
Your Lordship, in similar matters, Your Lordship directed for issue notice and filing counter.
Your Lordship, but
All right.
Yes, yes.
Issue notice on the question of admission. Counter can be brought within
Counter file.
3 weeks. 3 weeks.
Yes.
Place the matter 3 weeks after.
Pardon me, that item 12 has sought the copy of the judgment. My learned friend has gone through the judgment.
Gone through that judgment? Yes. And this covers. Then I will set aside the
Annexure 1.
Item kete?
12. Item 12.
Supreme Court judgment at diyon to
They do. 2 judgments I have. Annexure 1 is the order that will be request and revisit the matter by the
Annexure 1 is the local
local order. Yes. 2 judgments I have.
And matter will be remanded
back to the London Civil Court to revisit.
Back to CJ Junior Division na Senior Division?
Civil Division. Civil Judge.
Senior Division.
Minor.
Section 18.
Yes, yes.
Section 18.
Senior Civil Judge Nuapada.
Senior Civil Judge.
Senior Civil Judge Nuapada. LAR number 07/17.
Nuapada se case number lekha hava na to decide. To decide the matter afresh.
Yes, my lord.
It is the boss file, right? Yes, you will get today's order.
Much obliged.
Your Lordship, item 33 similar matters have been disposed of by.
Just 1 minute. Mr. SAHOO, State Council. So it will be by way of a small judgment, so that it will help subsequent cases also. Is what you say?
Your Lordship, item 33 similar matters have been disposed of by Your Lordship.
Dispose a counter file karibe kouchani mu jodi samay na debi writ appeal file hoji age amu samay deleni counter file.
Writ appeal has already been disposed.
Please. Asu jotole asibo setole dekhebeni mu januchi bhokta is anxious to finish it before me. I have trust on the other judges also. Yes.
Item 34.
Radhacharan
Das, there is no such person died.
There is appeal provision in the miscellaneous provision rules.
Yes, my lord, there is appeal.
So why are you come to the High Court?
Liberty be granted.
Liberty kon naba pe High Court asibe apon.
The lordship dispose.
There is statutory, clear statutory remedy of appeal. Writ petition in this circumstance not entertainable. Permitted to be done, however, with permission to the petitioner to bring statutory appeal.
Item 35.
May I please, your lordship. This is a matter, my lord, where the plaintiff and defendant filed 2 suits, and both the suits are analogously had and passed on judgment by annexure 1. While the operating portion of the judgment, it has been stated that if your lordship turn to page 65 of the running page 65 of the annexure 1, madam. There, their lordships are stated while ordering portion, it is further directed that the parties shall explore the possibility of amicable settlement within 3 months from the date of this order, failing which either party is at liberty to initiate final decree proceeding. Furthermore, the office is directed to fix a date to trial final decree proceeding as per ratio laid down by so and so Honorable Supreme Court order. And by virtue of this common judgment, accordingly, both the suits, that is suit number 564 and suit number 448 of 99, disposed of.
Right. Suit is ultimately concluded.
Concluded. But surprisingly, one of the plaintiff, the suit was judgment was passed on 29/3/2023. He preferred a miscase, not a mutation case. He preferred a miscase before the Tahsildar. In view of that miscase, he has corrected the ROR.
But dependent on the decree or not?
No final decree has been, what I have shown to you lordships, within both
What
parties.
is the ultimate judgment?
Ultimately, judgment was that they have stated, and preliminary decree also the Honorable Court has passed. In the preliminary decree also, they have stated the party is at of liberty to initiate a final decree proceeding if the amicable settlement not within the 3 months. While within 15 days thereafter, he filed an miscase 18 of 2023 before the opposite party number 2, and the opposite party
Then
number
appeal lies.
no, my lord.
Appeal lies.
No, my lord. If
Why?
it is
It's
a
a-
mutation, if it is a mutation case, then appeal will lie. It is a miscase. No appeal will.
No, miscase then under what provision of law?
They have not stated. If your lordship turn to Annexure 5, the impugn order, my lord, which is at
Yes.
page 111, my lord.
Yes,
I know.
This is in the trap of mutation, Mr. Jetty.
If it is a
It has
mutation
been
case, my lord,
nomenclated
appeal is
as a
there, I know, my
miscase,
lord.
but it is in the trap of mutation. Ultimately, what he is directing for correction of the record of right.
Yes, my lord.
So it is in the trap of mutation order. So then appeal lies.
Thing is that if your lordship turn to Annexure 3, he has sent notice to 4 persons, leaving all the other defendants, my lord. I have not been noticed.
You have not been noticed. That you say.
Yes, my lord. Annexure 3, my
Alright,
lord.
you produce record then. You produce record to find out. And then, Mr. Jetty, why are you not filing certified copy of
I have
impugn
filed.
order?
I have filed the certificate copy of the impugn
You
order.
have filed.
Yes, my lord. Annexure
Where?
5.
Where you have filed?
In this case, my lord.
My brief, it is not there.
And perhaps it must be after the Annexure 4, my lord.
After or
Annex-
before? No,
Annexure
after
4.
Annexure 4, it is definitely there, but it's a Xerox copy.
Annexure 5 is the
Yes,
certificate.
5 is a Xerox copy.
It is in the right hand side. It is compared. Your lordship may see compared in the blue seal.
Oh, compared record keeper.
Yes, my lord.
So nowadays they are giving Xerox copies.
Yes, my lord.
All right, it is certified copy. All right, there is serious allegation of undertaking an exercise by the Tahsildar Barango in miscase number 18 of 23 without involvement of the parties likely to be affected, such as the petitioner or petitioner's herein.
Petitioner's
herein. At the same time, attention of this court has also been drawn to the judgment in the civil suit involved herein to submit that the preparation of record of right directed by Tahsildar Barango by Annexure 5 remaining complete contrary to the judgment involved herein. Okay, to find the allegation through the records of the Tahsildar Barang, this court, while directing service of 2 copies on the State Council, by tomorrow, as undertaken, State Council is directed to produce record involving miscase 18 of the proceeding file, miscase 18 of 23 on the next date of posting. So 10 days after Asivo.
I have prayed on miscase not to create any third party interest.
In the meantime, if the order at Annexure 5 is not given effect to, say, may not be given effect to till disposal of the writ application.
Deeply obliged.
Item 36.
May I please, your lordships, my lord, prayer for early disposal of section 8 capital A OLA proceedings, my lord. And section 8
8A will are proceeding.
Aye.
Okay, petition involve following prayer, it appears. The read petition is involving a innocuous relief in as much as in the disposal of the section 8A OLR proceeding, OLR Act proceeding, wide miscase number.
My lord, in the prayer, I have mutation case number.
Mutation case number 6181 of 23.
Yes, my lord. Yes, my lord.
What is the notice stage there?
In paragraph 9, I have stated, because they have sent it to the development authority, and your lordship knows in view of rule 12 hyphen capital A sub rule 1 and B, clause B, the requirement is that if the no objection is received from the development authority, then it is deemed to have been
accepted.
They have no
That
objection.
He will consider. So notice has been already given.
Yes, yes, my lord. In paragraph 9, I have stated, my lord. Opinion has been sought for from the Cuttack
Considering
Development
the
Authority.
nature of the proceeding, this court direct Tahsildar Cuttack for bringing out a lawful outcome involving such proceeding at least within a period of 2 months from the date of communication of order.
My lord, keeping in view annexure 6, I have submitted other documents in support of the fact
While
that
also taking into consideration the grounds taken in the writ application as well as documents appended herein to support the case
Obliged.
of the petition.
Obliged.
Yes.
Item 37.
These are
May I
all
please
the
do not?
same.
Same matter.
Same.
matters.
Yes, that's 7.
My lord, demarcation application is pending before OP number 3.
Demarcation case number you find here. You find the case number.
I don't have the number, my lord.
Then
Kindly
how do
see
you
annexure 2 series, my lord.
How do you establish the demarcation?
Annexure 2 series, page 9, my lord.
2 series. Page 9.
9. That is the receipt of the.
Receive.
Yes, my lord.
On deposit of the.
Yes, my lord.
Okay, annexure 2, page 9 establishes petitioner to have brought petition for demarcation pending before OP number
3, my lord.
3. OP 3 is directed in the event it is in receipt of demarcation application by the petitioner. Same should be given a lawful disposal, but however, in the involvement of party likely to be affected by completing such exercise within a period of 3 months from the date of communication. RFS we say annexure 2 page 9. Ethereal annexure 2 page 9. Data of annexure 2 page 9. Right.
Item 38.
My lord, this case may kindly be taken up tomorrow. My senior is ill. This case may kindly be taken up tomorrow. My senior is ill.
All right. Tomorrow?
Tomorrow, man.
Day after tomorrow. Day after tomorrow. But instead of giving objection, why are you approaching this court at this stage? Right, all right.
Item 39.
39, my lord. Early disposal. Matter is pending before the opposite pattern 1 in 2007.
Revision case, it is after notice.
After,
There it is pending after notice.
after notice.
Okay, considering
Present prisoner filed a
revision case
WP7
288 of 2007 is pending for nearly 14 years. The Commissioner Consultation Settlement Odisha Cuttack is directed to give a lawful disposal to the same at least within a period. It is pending achi.
pending.
Nahi to?
Remand revision case.
Remand is
OP number 1.
Sub collector
come to page 18. Okay,
Before
remand
sub-collector.
is- Sorry, cut it. Like a petition, counsel for the petitioner taking this court to direction paragraph 5, page 13, page 18 of the brief. As an outcome in revision case 288 of 2007 brings to the notice of the court that by virtue of final outcome dated 15/4/13, There has been remand of the 37-1 proceeding to the consultation officer Kendrapada for adjudication of the dispute under section 11 of the OCS and PFL Act with further direction therein. Bringing the writ application, it is alleged, even though the remand order was passed on 15/4/13, there has been no progress as of now. Considering the submission of learned counsel petitioner and after involving the submission of state counsel, this court, while expressing its anxiety in long pendency of proceeding of this nature, in the disposal of writ application, direct the consultation officer Kendrapada to bring a lawful outcome to the dispute in pending before him and remanded for adjudication by the order of the Commissioner of Consultation in the disposal of revision case 288 of 2007, at least within a period of 6 months from the date of communication of the order, but in the involvement of the parties likely to be affected. Free copy of order be handed over to State Council.
Item 40.
First content.
First content.
Mine.
Item 40, my lord, this content is not maintainable, my lord.
Not maintainable?
Yes.
Why?
Your lordship may kindly see the order passed on 7/10/2016. He supplied copy to Tahsildar on 15/7/2022.
Limitation, you say?
Yes.
That means you say that since there is delay, you will not work out the direction of
No, that is not.
How then? Why are you not bringing out an outcome? I will convert this to a writ petition and give a mandamus.
Yes, you can file a writ petition.
Is that the argument?
Your
Even nahi, jodi challenge hi nahi eta Supreme Court re. You are bound by this order. Yes. Undisputedly, there is no challenge to the order of this court dated, judgment of this court dated 7/10/16, passed in ODC 5715 of 19. Provided the judgment involved herein is not varied in higher forum, public authority is bound by such judgments. Content application cannot be rejected on the ground of related public authority involved herein should bring an outcome in terms of the judgment. In so and so, dated so and so, 7/10/16, in so and so, by completing entire exercise at least within a period of 3 months from the date of 2 months from the date of communication. Ask them to work out instead of contesting. What a judgment ko frustrate kar debe ta mane.
No.
Item 41.
What will be first content?
First content.
First content.
Direction to
Please, Your Lordship.
direction to OP number 5.
I had come here to dispose of my 15B application. Your Lordship, taking into consideration the age of the petitioner, 70 years old. Your Lordship directed to dispose the matter within 3 months. My Lord, kindly see the order passed by the Supreme Court. Order dated 12/9/2022.
देखिकिरी कुआ हितला जल्दी सारंतु बोली.
My Lord, I moved it with the certified copy, and the Lord Commissioner received it and gave an endorsement. By my file is lost to elsewhere. I could not get my file.
Notice kar do. Serious allegation of non-compliance of High Court order, particularly keeping in view the age of the applicant in the writ petitioner, already 70 years by the time moving High Court. This court is inclined to issue notice on the content now. Pendency, notice accordingly. pendency of the contempt application shall not stand as a bar even giving an outcome in the proceeding RP 387 of 2007 in the meantime and reporting the court accordingly.
Yes, madam.
Our case ta kono? Oita read order ta.
Order.
All right.
Oblige. RP 387. RP 387 of 2007.
RP number lekha hai paas.
हाँ, oblige. Sorry, I'll start back.
देखी दो ना impugned order रे RP number इस्ते. Please.
Item 43.
43 will come 10 days after. 43 will come, let some other judge take decision. Yes.
Actually, it
Both the
was almost
proceeding 10 days after. Date kar diya, 2 weeks for a date kar.
offer
In the
was
assigned dates.
made at the
That's
highest.
right, I have
rate.
given a direction. I don't know why they have filed a review
Review, my
application.
lords. Yes, my lords.
The
If they
state
have
will
something in their mind, let
We-
some other court decide.
We made review because the reason that the district level.
Forget that. Argument was made or not.
Yes, yes,
You
yes.
were provided opportunity or not.
Yes, yes.
It's a reason order or not. Review, what is the concept of review? Is there any new ground to be considered? Raised
Problem-
and not taken?
Problem is that the committee
No, no.
chairman
Is there
is.
any ground to re-adjudicate and not adjudicated even in spite of being raised? Nahi. Is it contrary to law? Nahi. So let some other judge decide whether my view is justified or not.
As your lordships, yes.
Yes.
And my lords, your lordships, their own letter which
Yeah,
gave
their
the
own
highest.
letter,
Your lordship said that.
their commitment, their letter, everything I remember
Everything
very
is
well.
correct. Yes,
Even
sir.
then they want all that.
Letter by the collector.
ଶୁଣ ଠାକୁର ଜଗନ୍ନାଥଙ୍କର ଜିନିଷ
ମୁଁ
ତେଣୁ ଆଉ ଜଣେ କିଏ ବି ନେଇଯାଆନ୍ତୁ ଆଉ ଗୋଟେ ଭ୍ୟୁ ନିଅନ୍ତୁ ଯଦି ନେବେ ନେବେ ଭଲ କଥା ନାଇଁ ଯଦି ସେମ୍ ଭ୍ୟୁ କନଫର୍ମ କଲେ ଇଟ୍ ଇଜ ଅଲ୍ ରାଇଟ୍
ଆଜ୍ଞା
ପ୍ଲେସ୍ ଦିସ୍ ମ୍ୟାଟର 2 weeks after କରିଦିଅ ହେଲା ଡେଟ୍ କରିଦିଅ
ଆଜ୍ଞା oblige.
wait for some time.
Yes.
Item 44.
May I please, Your Honor. Here the contemner is a CDMO at Barampur.
In the meantime, Mr. Satpathy, yes, this is not ready for hearing.
Yes, yes, sir, not yet been. I will.
Yes, ହେଇନି ଆପଣ କରୁନାହାନ୍ତି
Certified copy of the order.
certified copy.
We have filed it a
Sir,
free copy.
Review the order karo. There is no filing of certified copy
That will make.
for which there is no SR even. Let the certified copy of order be filed within 10 days. ହେଲା. Consequential SR be made and the matter be placed 2 weeks after.
Yes.
Along with contempt number so and so.
Yes.
May I please, Your Honor. Here
Yes,
my contempt-
no contempt will come hereafter till my retirement. Okay. Let the contents be lie over.
Here the contemptor is
Is
the.
fast contempt.
Oh, this is the only contempt, my lord.
Huh?
Where he has only contempt, he has
Writ pending.
violated the
Rita pending ଅଛି.
writ pending thai interim order violate kari the other side ku ଦେଇଦେଲେ
They are
license
not
ଟା.
complying the interim order.
Yes. Knowing fully well that matter is sub judice and
Notice ନିଅନ୍ତୁ. Notice contempt.
Item 45.
I'm pardon my lord, I'm virtual. But
Yes, Mr. Janna.
yes, my lord, this is fast contempt. Your lordship passed an order that 14/2/2023 that the additional commissioner.
All right,
consideration-
fast contempt. Fast contempt. ଶୀଘ୍ର ସୁଇଚ୍ ଅଫ୍ କରନ୍ତୁ ସିନିୟର କାଉନସିଲ ମୁଁ ପେନାଲ୍ଟି କରିବାକୁ ଚାହୁଁନି
Item 46.
ଶୀଘ୍ର ସୁଇଚ୍ ଅଫ୍ କରନ୍ତୁ
I'm sorry.
ଡାଉନ୍ କେମିତି ନାହାନ୍ତି ସିନିୟର କାଉନସିଲ କଣ କରିବ
Item 46.
2 weeks after କରିବେ ଏଇଟା ବି ସେଇ ମ୍ୟାଟର କିଶୋର ଜେନାଙ୍କର ଅଛି
Not 40.
That's CDR.
45 ଟା କିଶୋର ଜେନାଙ୍କର
Ah, 45 ଟା.
ଓକେ ଅର୍ଚ୍ଚନାଙ୍କର କଣ ଏଇଟା ଫାଷ୍ଟ କଣ୍ଟେମ୍ପ କି ଦେଖିଛନ୍ତି ଆପଣ
Item 46.
46 ଟା. First contempt.
First
That's CDR.
My lord, I mean virtual mode, sorry, my fast content, my lord. Fast
Okay, all right.
content,
all right yes
my lord, notice on special messenger.
notice କରିବିନି fast contempt ରେ I usually give provide further time
My lord, in this case, some problem has been created. Your lordship has granted them
Release कर दियो 2 weeks after. 2 weeks after
I have
ଆସିବ.
taken loan from a bank.
Okay.
And bank-
Let us see.
Item 47.
47 को first contempt की.
First cut.
First contempt ले dispose कर. Mr. Ratha, you may not wait. I will not take up any hearing. Very few, some minor hearings I will take up.
Sir, most of the minor भी.
नहीं हबनी आज्ञा. मु नेबिनी आउ hearing. Please excuse me.
हमें sir other side
order extend हबो. I will not take up any hearing except some very few एकदम covered order रा अच्छी जो.
Item
may not be any matter there.
item 48 टा covered matter.
So देखिए रुहନ୍ତୁ go see the 48.
Item 48.
हाँ.
48 रे सेकंड मैटर टा डीलिंग हे जाबो ते भूलले पळे आस्ति.
सेकंड टा भूलले पळे आस्छि.
कना से कोनसी कनेक्टिविटी नाही अलगा केस पुरा.
नहीं हमरो कोन अछि कि जो नोटिस प्रोस्पेक्ट रे सबुडा के एकाठी करी पठै दउचंदी. So first case रे कोन हैला requisites for issue of fresh notice by speed post in his correct address not received.
Settlement officer. Not no notice दरकार covered by
अरे आपण covered जे जदी OP3 टा प्राइवेट ही तो मु डिस्पोज करि परबी की.
settlement officer.
सेटलमेंट ऑफिसर और नोटिस डायरेक्शन किए देथिले.
Assistant settlement officer Sampur. On the last occasion, your lordship directed me to.
Lordship, I've examined. It's covered only one aspect I want to point out. Because here they have bought it from the vendors.
Then hearing release कर दिया. OP number 3 टा की देखिले.
It's the assistant settlement officer.
Assistant settlement officer.
So
Here appear.
no notice is necessary.
Not necessary, my lords.
एटा बोधे आउ को बेंच रो नोटिस हेतिबो.
Lordship.
ये सब मैटर रे नोटिस कर दउतले.
13/10/2014 order.
Government parting भी notice हे जरूरी. Yes, notice the defect on notice aspect ignored. Matter needs final hearing. Sri Niranjan Lekha seeks coverage of the judgment of the order of this court in WPC so and so and so and so. Hala. State Council wants argument in the context of the proceeding. Place the matter in its own serial. Second matter ta se कहउछंती not
Lordship secretary.
to secondary independent order करो.
Mo case टा dispose.
Secondary defect कौन आछि?
Mo case टा सेटा dispose of हे जा covered matter अनुसार. My learned friend.
आज्ञा सुनतु आपण से माने जेतोले कॉन्टेस्ट करूछंती काने क्लोज. आपण जानुछंती रिट अपील केमती बाडिया होउची सिंगल जज मानको. आ जानि कि काई हमकु ह्यूमिलेट करूछंती. आपण मन तो सेठी हमर प्रेस्टिज को अपहोल्ड कुकिंग to maintain a writ appeal. There is no Supreme Court judgment saying if there is possibility of two views, writ appeal is not entertainable. There is no availability of Supreme Court decision to establish, unless it is coming within the trap of the letter patent, no writ appeal should be entertained. There is no limit in approaching the Supreme Court. State can very well go to Supreme Court challenging these orders. It is it's a regular matter. Regular entertaining writ appeals. Je writ appeal file kala, sabu writ appeal entertain gala. Then what is the meaning of these roster assignments? I am junior, therefore I have been assigned with smaller matters. There is a serious matter, two judges have to apply their mind. Yes.
947.
सेटारे भी कौन ही ची आपनकर से किए opposite party number 2 and 3.
In this case, I am
Opposite party number 1 and 2, we have already filed a counter, your lordship.
That's right, but who are 2 and 3 or 2 you have filed counter?
My lords, we have filed.
A counter
Three it will
will
be.
be given
Now
to me
the
also.
defect shown in respect of 2 and 3. Okay, so matter.
So OP3 only needs
Just
to be.
assist who are 2 and 3.
Lords, 2 is the Child Welfare Committee.
So are you representing them?
Lordship, we have already filed a counter.
So you have filed counter.
My
Then
lords.
3 is private party.
3 is private party.
I have appeared for 3.
You have appeared for 3.
My lord.
in
Okay, you are for OP.
Lordship,
My lord, but the counter copy filed by my learned friend Mr. Mishra has not been given to me.
Oh, you please.
I'll serve a
extend.
copy. I'll
You
serve.
Please extend. Yes, Lekha, etare. There is already filing of counter on behalf of opposite party number 2. The documents in the writ application further also disclose there has been already appearance on behalf of OP number 3 by way of caveat. Let the copy of brief as well as counter filed on behalf of OP 1 and 2 be exchanged amongst other parties available herein. Interim order ଅଛି କି ଦେଖ
ନାଇଁ ନାଇଁ ଏଥିରେ entry order ଆପଣ କରିନଥିଲେ caveat ରେ ଶୁଣିକି।
Okay, right. Right.
Right.
Yes, now
Item
49.
49.
49, my lords, I have filed this miscase, my lords, because the writ petition has been disposed of on the premises that I have filed the objection case which was rejected, but fact remains-
Pardon?
My lords, the writ petition was disposed of by the order, my lords, on the premises that I have filed the objection case which was rejected, but fact remains it's a suo motu objection case filed by the state government, my lords, which was allowed. Lords, Annexure 1 is the impugned order in the writ petition.
Yeah, you could not in a position to produce any document.
No, here, my lords,
I asked for a query and asked you to establish your submission.
Lords,
there is no document to establish such submission.
Here, my lords, I may be allowed, my lords. Annexure 2, my lords, sale deed was prior to the settlement. My lords, mutation was allowed prior to settlement, my lords, in 1993.
Order recall करती है ना. Order 18/8/23 stand recall. Matter be placed for. This was for final hearing.
Yes, my lords.
Now let matter be placed for final hearing in its own serial.
Item
in
50.
In the allowing of the IA. Yes, item 50. You get modification of order. Or modification, vacation of interim order. It will be finally heard, Mr. Ratha. Not possible.
I have no problem.
Final hearing necessary. Matter delisted to liberty granted to the learned councils for praying for expeditious hearing in the next assigned bench. Interim order ଅଛି କିଛି କି? ଅଛି.
ଆପଣ ତ order ସବୁ ଦେଇ ଦେଇଥିବେ।
Interim order to continue.
ଆସିଲା ବେଳକୁ ସେ କହିଲେ ଯେ ଏଇ order ଟା modify ନହେଲେ ହବନି। ତେଣୁ honorable single judge ପଠେଇଲେ modify।
That order
ସେ
will
ଯାଉ
continue.
ସାର୍ ସେଠି ଯାଉ ସାର୍। ଏଇଥିରେ ମୋର କିଛି problem ନାହିଁ।
Item 51.
51, my lord. After 3 years, this is a better relates to the service matter regulation of the petitioners.
No, why it has come today?
My lord, modification petition filed by the international petitioner.
May I submit, my lord? In this case, my lord, kindly have a glance to my lord's passed an interim order.
They are not party to this.
Yes, considering the submission made and keeping in view the above circumstances, this court, while not inclined to issue notice in the matter.
IA number 16033 of 2020, dated my lord 6/1/2021.
Okay, all right.
This is in connection with
as given in Annexure 568 series may not be finalized.
in respect of staff nurses in MHU and RBSK scheme under Hon'Ble district. But what happened? We are under NHU, another scheme. But what they have done is, but government is not.
You want final hearing?
No, my lord. Only modification to the extent already, my lords, in another case, my lords modified the order. We are under NHM scheme, National Health Mission scheme. We want regularize. What
you want regularize means you are intervening.
We have been appointed. We are not taken into consideration in view of this interim was passed in respect of Hon'Ble district.
My lord, intervener of Sudargarh district.
Your district is all
different.
So how can this order bind you?
Bind you. That is
No, Mr. Mahapatra, just 1 minute. In that event, what is the scope for entertaining an intervention?
I'm submitting that. Well, kind of a glance to that. Government, my lords, referring to this, my lords directed in another case.
No, could you catch my point?
Yes, my lords. So far,
in an intervention, I cannot pass such order.
That exactly, my lords. I'm not submitting that, my lords. I am submitting, referring to this order of my lords, The government is not extending us the benefit in spite of the order passed.
Right, bring a writ application.
Then that writ application
They have
might
filed my
be
order.
So therefore that there it will be decided.
That
not
writ
here.
petition has been filed
Only-
Oh,
correctly.
Mr. Sahu, why are you arguing?
a.
I have understood.
Well,
But
They have a problem. There is wrong advantage, due advantage taken of a order. So can that be cured in an intervention application? Intervention is either to support or oppose.
but
That's all.
support or to support all opposed ballots. That's exactly what my
You
lord says.
support. Then if you want not to be affected by this order
Yes.
and there is misjudgment of an interim order of
Yes.
this court, bring appropriate application.
But application I filed minus intervention, but unless intervention allowed, we cannot.
Intervention habani.
But we have to file minus, we have filed a miscase minus for
Sorry,
modification.
no miscase even permissive.
So then
You
we
are
are
not a party in the proceeding.
already my lords have all passed a judgment, my order my lords modifying that order. But in another case in respect of Bhadrak district. my
In
lords.
case habani.
In case of Bhadrak district. my
Yes, next.
Item
lords. But I may be
52.
permitted to give a leave my lords, I may be given a leave my lords to move that.
Pardon?
I may be given a leave my lords so that I can move it.
Yes, I to reject kar do chhi tale.
I
Yes, lekha. There is serious allegation by you of intervention that public authority taking illegal advantage and misunderstanding of the order of this court, interim order of this court, dated 6/1/21, affecting the regularization of the petitioners.
petitioners my lords in respect of Sundargarh district.
Intervention petitions, but in respect of Sundargarh district. Filing the another application, the interveners also seeks modification of the order dated 6/1/21. While clarifying that the order dated 6/1/21 in IA 16033 of 2020 is only in respect of Hon'Ble. This court observes in the event the intervener petitioners have any difficulty, as stated in the intervention application, are at liberty to bring appropriate application. Clarification भी कर दीजिए. This is only in respect of Hon'Ble.
That exactly that line my lords clarification.
Item 52.
52 ଆଉ କୋଉ କୋର୍ଟ କୁ ଯିବ? ଗତ ବ୍ୟକ୍ତିଙ୍କୁ ମୁଁ ଶୁଣୁନି, ତେଣୁ ଆଉ କୋଉ କୋର୍ଟ କୁ ଯିବ?
My lord, so far as sub item 4, that my lord has already allowed that on Friday, but while correcting the order, my lord find that the
54 ରେ ବହୁତ ଜିନିଷ ଅଛି. 54 ରେ ଯୋଉ
50
CMAPL 552 ଟା
52, my lord, 52 sub item 4.
52 ରେ ଟିକେ ରୁହନ୍ତୁ, 1 by 1 ଯିବା. ये CMAPL 785 of 22 ଏଟାରେ ଡିଫେକ୍ଟ କିଏ ରଖିଛନ୍ତି? ହଁ, JR ଦାସ ମ୍ୟାଡାମ କୁହନ୍ତୁ.
I will verify.
Please be on mic.
I will verify and remove the defect by day after tomorrow.
Is it a contest against state only or private
Yes,
parties
yes,
there?
state only.
State
that
only.
matter.
So, Mr. Mishra, let me allow this CMAPL. What is
Lordship.
there? Yes, CMAPL allow kar do. Grounds, considering the grounds stated and looking to the contest between the private party and the state alone. This court is inclined to allow the CMAPL in the restoration of WPC 18025 of 08. Please. All right, second case to be listed with
Obliged.
some other bench, as this court is not inclined
I am,
to hear one of the counsel. Then CMAPL 553 of 18,
my lord, delay of 38 days, my lord.
pardon, condonation delay.
My lord,
Notice कौन ହେଲା?
notice as a paper publication.
Paper publication ହେଲା ପରେ ବି appear କରୁନାହାନ୍ତି?
No appear kuru.
Okay, in spite of paper publication, nobody is appearing. In the delay condonation aspect, IA 269 of 18, considering the submission, this court, कितने दिन delay?
Delay of 38 days, my lord.
38?
My lord.
Okay, considering the delay of 38 days, this court, while inclining to allow the application, allows the application, however, subject to petitioner depositing a sum of rupees 2000 in the advocate welfare fund, High Court.
Well,
आज deposit कर देवे?
kali kar devi.
In the, okay, and the receipt of such deposit be made by tomorrow. In view of the commitment to deposit the cost, this court considers the merit involving CMAPL. Considering there is genuine ground of non-appearance, this court allows the CMAPL. Yes.
Well.
Subject to, however, furnishing the receipt on deposit of this.
Well.
Yes, next.
Four-
Here also condonation of delay.
472,
ଏଟାରେ ମନା କରିଥିଲି SK ମହାନ୍ତିଙ୍କ ନାଁ ଆଉ ରହିବନି କାହିଁକି ସେ
my lord, that was deleted. Direction was to direction
already delete ହବା ସତ୍ତ୍ୱେ ହଉନାହିଁ
22 order ରେ ଅଛି already
Yes,
deleted.
court master, take this matter with the person concerned. Why this is again repeatedly appearing? This man is no more even. Yes,
My lord,
condonation of
that-
delay ରେ notice ନେଇଛନ୍ତି।
My lord already appeared, my lord.
I have filed my wakalatnama since.
ସେଇ appear କରିଯାଇଛନ୍ତି। ସେଇ
On-
issue ଥିଲା condone ନ କଲେ CMAPL ଟା allow ହେଇପାରି ନଥାନ୍ତା।
Actually
ସେଦିନ
24
actually ସେଇଟାକୁ କେହି point out କଲେନି ତେଣୁ ମୁଁ matter ଆଉ ଥରେ ଆଣିଛି।
my lord.
ଏଟା delay ଟା condone ହବ considering the submission of Sri Verma.
My
You are appearing for
PHL, OP number 2. PHL, my lord. Opposite party number 2.
OP number
I have filed my wakalatnama since 4.
ଦିଅନ୍ତୁ ଭୋକାଲାତ ଦେଇ ଦିଅନ୍ତୁ।
But that has not been reflected. I have already filed, my lord, since.
Okay,
long.
all right, ତା ନାଁ ଲେଖିଦବ ହେଲା। Yes. I thus stand alone. CMAPL ରେ considering the submissions and the grounds, genuine grounds, the CMAPL stand allowed with restoration of the
Subject to payment of some cost. my-
arbitration appeal 23 of 18.
My lord. Subject to payment of some cost, my lord. Is a big industry, my lord, subject to
Big industry, କେତେ
My-
ଦିନ delay?
200, more than 200 days, my lord.
More than 200.
200, that is their.
କିଏ petitioner counsel
My
କିଏ?
reasonable cost.
ଆଜି ଦେଲେ ବୋଲି ଲେଖି ଦଉଛି ଦେବେ ତାଙ୍କୁ।
My
ହାଁ?
My-
ଆଉ subject to condonation of subject to however payment of କେତେ ଦିନ delay କହୁଥିଲେ?
229 days.
293 days, actually
Three-
pointed out 293
3,000.
days.
3,000
My lord.
paid in court. Yes.
Extra copy of sir.
Then CMAPL 131.
My lord, state is party, there is a delay. Your lordship, there is a delay of 2,908.
Other side appear କଲେଣି କି?
State is party, my lord, here.
No,
Only.
Mr. ପରିଜା ବି ଅଛନ୍ତି ନା କଣ?
No, no, here, no.
ନାଇଁ?
No, my lord.
Okay, କେତେ ଦିନ delay?
My lord, delay 2,980 days.
2,900.
Because my lord, Mr. Ramchandra Sodangi was died, he was the conducting counsel. So it was not informed to the
Then you
party.
sharp copy ଆଜି ବି list ହେଇନି। You sharp copy matter will come later on.
My lord, I have filed the delay petition. Limitation petition I have filed for
କରିଛନ୍ତି କିନ୍ତୁ ଏଠି ଆଜି listing ନାହିଁ।
that has
କେତେ
not.
number ସେଟା?
233.
233 ଆଜି list ରେ ନାହିଁ। ଏଟା SR ହେଇନି। Let a copy of the limitation petition be served on state council. Limitation petition by IA number
233, your lordship.
233
My lord,
of 23.
23.
Be taken, be further listed again on next Thursday. Yes, next, along with the CMAPL. ଆରଟାରେ ବି condonation delay ଅଛି, Mr. ପରିଜା।
My lord,
କେତେ ଦିନ delay?
4 ବର୍ଷ 2 ମାସ।
ମାତ୍ର
ଆଜ୍ଞା।
ପ୍ରାଇଭେଟ ପାର୍ଟି ଅଛନ୍ତି
ପ୍ରାଇଭେଟ 8 ଜଣ।
notice ନିଅନ୍ତୁ।
ଆଜ୍ଞା।
Notice in the matter of limitation. As undertaken, requisites by day after tomorrow. Matter be placed immediately after service of notice. Yes, CMAPL, then next one.
My lord, 222.
Jajati Mahanti.
My lord, 222. There is delay of 39 days.
39 days ହେଲେ ସେଇ only government.
Only government.
Okay, ସେଇ order ହବ ଆଙ୍କର ଆରଟା ଯୋଉଟା limitation copy be served on state council. IA number?
Sorry, I have not filed the I.
No, sorry, let there be filing of IA for condonation of delay. Matter, the CMAPL will be listed along with limitation petition if any. Yes, next CMAPL.
My lord, government is the only party, my lord.
Government
is the only party, my lord.
Government is only party. ସେଥିରେ କ'ଣ counter ଅଛି କି କ'ଣ delay ନାହିଁ?
ନା
delay ନାହିଁ?
ନାଇଁ ନାଇଁ।
Okay. Yes, allow କରିଦବା considering the ground stated here. In restoration of OJC 13257 of 01. Next, there is delay condonation.
My lord, notice to be issued
Notice
on delay.
All right, CMAPL 269 re IA 108 notice you, requisites as undertaken. By day after tomorrow, matter will be placed immediately after service of notice and appearance of parties. Okay, then CMAPL 523.
State
is complete ହେଇଯାଇଛି.
My lord.
କିନ୍ତୁ ଭକାଲତ ଏଥିରେ କଣ state Anil Kumar Behera.
My lord.
State is the only party.
My lord.
Verify through the court title. State is the only party.
State is the only party. Matter relates to rehabilitation appointment. My lord.
Copy ଦେଇ ଦିଅନ୍ତୁ CMAPL ର copy ଦଉନାହାନ୍ତି.
Copy ତ ଦେଇ
ଦିଅନ୍ତୁ ସାଙ୍ଗେ copy ଟେ.
So I have to point out something here, Lordship.
Okay,
CMAPL number.
The ground stated herein, this court find since the ground genuine. This court allows the CMAPL 52323, thereby in restoration of the WPC 3487 of 03.
Lordship, that is the issue here, Lordship. WPC 3487, Tara CMAPL is not 523 of 2023, it's 523 of 2022. Good. Lordship, ये जो रेट टा पाई जो CMAPL फाइल को है that is Lordship 523 of 2022.
523 list is the
Lordship 2023 list है CMAPL 2022.
533.
Lordship 523 of 2022.
22.
Lordship.
এটা ভুল ରହି ଯାଇଥିବ 23 ଲେଖା ହେଇ ଯାଇଥିବ ଦେଖିବ ହେଲା ଆମେ କିନ୍ତୁ ଯଦି 23 list ହେଇଥିବ ତାହେଲେ ଏଟା it is not in connection with WPC number so and so କରିଦବ ଆଉ ଥରେ list ହବ ହେଲା এই WPC ର number ଟା actually 522 sorry 523 of 22 ବୋଲି କହୁଛନ୍ତି ସେ so file ଦେଖିବ ଯଦି 523 of 22 ହେଇଥିବ ତବ ହବ ଯଦି ସେଟା 522 of 23 2 ହେଇ ନଥିବ ତାହେଲେ list of repetition along with 523 of 22.
Great. Here more WPC OS number 1954 of 16, my lord.
Pardon?
WPC OSC number 1954 of 2016.
ସେଥିରେ
ହଁ
ତାହେଲେ 523 of 23 ରେ WPOSC number so and so ଦିଅନ୍ତୁ slip ଲେଖିକି ଦିଟା ଯାକ matter କୁ list କରେଇଦବା ହେଲା ଠିକ ଅଛି ତାହେଲେ ଆସୁ appropriate listing ରେ ଆସୁ ତାପରେ ଦେଖିବା yes this Mr. Atfyar Nath Lenka
non appearance dismiss ହେଇଥିଲା sir non appearance ରେ dismiss ହେଇଥିଲା
ଏତେ limitation ନାହିଁ
ନାହିଁ
କପି ଦେଇଛନ୍ତି
କପି ଦେ
କେବଳ state opposite party ନା private ଅଛି
sir state
କେବଳ ତାଙ୍କୁ କପି ଦିଅନ୍ତୁ yes ଏଟାରେ allow ହେଇଯିବ ନା ଏଗୁଡ଼ା କଣ ଆଣିଛ what are these matters ଏତେ ଗୁଡ଼ା orders କଣ list କରିଛ ଶୁଣ ଏଇ ଯୋଉ correction ପାଇଁ ଅଛି 55 ଗୁଡ଼ା ସବୁ undertaking 55 a typographical errors a batch of case typographical errors different cases so 55 ta done
54 ta
54 53 will be delisted
no 54 but khali only recall what happened in this case misrepresentation yes person concern died since long
no time
I only recall against the state
ପରେ ଆସିବ
order ସେଥିରେ actually ଭୁଲ order ସେ ମରି ଯାଇ
ଆଉ ବାକି ଯୋଉ
56 my lord item
56 କଣ matter
ସେଟା କାଲି କି ନଲେ ଆସୁ ପ୍ରେସ୍ ଆଡମିସନ ସେଟା ଆସି ମାନେ ହେଇନି ବନ
ସେ କଣ small matter ତାହେଲେ କାଲି କି ପ୍ରେସ୍ ରେ ନେଇ ଆସ
55 ଟା ଖାଲି correction ହବ
57 ରୁ ବାକି ଯେତକ ଅଛି ସବୁ delist ହେଇଯିବ ହେଲା
Lordship, item 53.
59 ଟା small matter expert adjudication
small matter ମୁଁ ନେଇ ପାରିବିନି
expert adjudication without notice ମୋ ଜମି ମୋ ବାପା ମରି ଯାଇଛନ୍ତି ବାପାଙ୍କୁ ପକ୍ଷ କରି expert adjudication କରି ଦେଇଛନ୍ତି
କୋଟା
I am 59
59
ଆଜ୍ଞା
59 ତ ଏ କାଉନସିଲ କୁ ମୁଁ ଶୁଣୁନି
ଆଜ୍ଞା ମୁଁ Mr. Nanda was appearing since he joined in government after consent I have appeared
ନାଇଁ ମୁଁ ଏ କାଉନସିଲ କୁ ଶୁଣୁନି ତାଙ୍କ ମ୍ୟାଟର ଶୁଣିବା ଠିକ ହବନି
ନା ମୁଁ consent
ଆଣିଲେ ବି ହବନି
ସେ ସରକାରୀ ଓକିଲ
ମୁଁ ଯାହାକୁ ଶୁଣିବିନି ସେ ଆଉ ଜଣକୁ ଛିଡା କରିଦେଇ କରେଦବ
ସେ ସରକାରରେ ଜଏନ କରିଛନ୍ତି ବା ସରକାର ଓକିଲ
ନାଇଁ ତାଙ୍କୁ ମୁଁ ଅଦୁରେଇ ଶୁଣୁନି ସେ ମୋ କୋର୍ଟ ଆସୁନାହାନ୍ତି 5 ବର୍ଷ ହେଲା
ଆଜ୍ଞା ମୁଁ ଜାଣିଛି
53 your lordship
56
53 my lords 53
53 Complaint माने contempt टा
Contempt, your lordship. There was a
कहाँ थी
direction.
विजय बेहरा कहाँ थी? Okay, लिखी दिया State Council submits. There has been already
कौनसी तहसीलदार
implementation of the order involved herein. Keeping this statement, clear statement of the State Council, Shri Mishra, the Council for Appeal, Shri Mishra, this court find nothing suffices to be adjudicated. Proceeding consequently dropped. Mr. Rath, ଆପଣ ଏପର୍ଯ୍ୟନ୍ତ ଅପେକ୍ଷା କଲେ
କଣ କରିବେ ମତେ
କଣ କରିବା?
58 item ଟା।
କୋଉ ମ୍ୟାଟର ଟା?
Item 58 ଟିକେ ମତେ ମାଇକ୍ 58 ଟା sir।
ଟେକ୍ ଅପ୍ କରିହଉନି ଶୁଣନ୍ତୁ ମୁଁ ମାନେ bar has so many fresh admissions pending ତେଣୁ fresh admission ନେବି ନା final ନେବି?
ନାଇଁ sir ଏଇଟା we both have discussed and your lordship will take 2 minutes time to resolve
Drop
it.
the proceeding.
My lord, that is
Discuss in the dropping of the proceeding or allowing the proceeding.
like he is from the LIC.
Hey, Mr. Das ଏପଟରେ
ନା
ଛିଡା
ତାଙ୍କ ପଟେ କିଛି ନାହିଁ
ସେ ଆଉ ଗୋଟେ ମ୍ୟାଟର ପାଇଁ ଛିଡା ହେଇଥିବେ।
ଓହୋ
आइटम 60 टा
ଶକ୍ତି ବାବୁଙ୍କର ଅଲଗା
ଆପଣଙ୍କ ପ୍ରବେଶ ପଥକୁ ସେ ଅପେକ୍ଷା କରୁଛନ୍ତି।
ସେ ବୋଧେ ସେ ଭାବିଲା ବୋଧେ କାଳେ ମୋର ପଡିଯିବ ବୋଲି ବସିଛି ଆଉ କଣ।
58 କୁ ଗୋଟେ କାମ କର ଶୁଣ शुक्रवार आउ किसी आनिबनी ओके शुक्रवार दिन 58 मिस्टर दास आपण को मैटर छे
सेटार मु अछि जे अपोजिट अदर्स अपोजिट पार्टी एतर ओडा नोटिंग अछि जे नोटिस रिक्विजिट दिया हैनी
आइटम
60 लास्ट आइटम टा
60 कोन सब पार्टी अपियर कर जाई छै
नहीं नहीं सर ओडा रिक्विजिट दिया हैनी ओडा लिखा है
टेक सम टाइम मिस्टर दास आई एम रिलीजिंग दिस
जो लॉर्डशिप
रिलीज करते हैला आउ काली ठु जेते हियरिंग मैटर अछि सब गुडा करे खाली देखिबो माने गोटा ऑर्डर्स कैप्शन रे एक्सटेंशन ऑफ इंटरिम ऑर्डर आनिबो सेति हैला
सर 58 टा को दिन रखले
58 टा फ्राइडे को रहला
आइटम 55 टा करेक्शन
54 टा the instance of the petitioner he wants recall. I 54 टा the instance of petitioner recall my lord.